pragmatist scholar. It's my pleasure to see you all again. We had a terrific day yesterday full of panels and lectures, and we have another day ahead of us. Somewhat brief relative to yesterday, not quite as full, but full substantively of some really terrific panels. So I'm really looking forward to today's presentations as well. And it's my pleasure to introduce, to moderate our first panel, my colleague, Joan Foley.
Good morning and welcome. Our first panel this morning is Cardozo's jurisprudence. And I'm delighted to introduce our panelists today. John Goldberg, the Eli Goldston Professor of Law, Harvard Law School. And at John's great suggestion, he suggested I keep the introductions quite short to the law school and position. So with that, I will move right on. We also have Ben Sapersky of Fordham Law School, the James Quinn Chair in Legal Ethics. And finally, Mark Graber, Regents Professor at University of Maryland, Carey School of Law. And with that, I turn over the mic to John and his discussion of Benjamin Cardozo and the death of the common law.
Thank you very much. Oral argument before the Supreme Court in Erie Railroad versus Tompkins took place on January 31st, 1938. Justice Stanley Reed, newly confirmed, was welcomed to the junior justice's seat at one end of the bench. The seat next to Reed's was empty. It belonged to Benjamin Cardozo. Cardozo had recently suffered a heart attack and a stroke from which he would not recover. The court issued its Erie decision in April. At about that time, Cardozo was being returned by train to his home state. Put up at a friend's home just north of his New York City birthplace, he died in July. His body was buried in a Queens cemetery located about an hour's drive west of us. If you go a half an hour further beyond that, you'll hit the Long Island Railroad's East New York station, the site of Paulsgraf. We will never know for sure what Cardozo would have done in Erie had he been able to participate, but it seems likely that he would have signed on to Brandeis's majority opinion, and not just because he was among the court's quote-unquote liberals. Cardozo had his issues with Brandeis. Both regarded themselves as following in the footsteps of Holmes, but each emphasized different aspects of the great man's legacy. Excuse me. Here's a crude way to put it. Whereas Cardozo drew from the common law an appreciation of the historically rooted complexity and richness of judge-made law, Brandeis saw himself as the path of the law's new man, the man of statistics and the master of economics. As Andy Kaufman's remarkable biography tells us, Cardozo thought Brandeis was too much a social scientist and too ideological. I believe Cardozo also would have chafed at Brandeis's overblown claim that Swift had relied on the false jurisprudence of the Brunig omnipresence and that Erie's holding was authentic to the true jurisprudence of Austinian legal positivism. Still, it was not Cardozo's habit to write separately. There is also evidence that he was not a fan of Swift's notion that federal courts were entitled to fashion general common law. Indeed, Irving Younger tells us that it was none other than Cardozo who, in July of 1937, granted Erie Railroad's request for a stay of Tompkins' judgment after it had been affirmed by the Second Circuit Court of Appeals. Cardozo's grant of the stay may suggest that he wanted the court to take Erie in order to modify or overrule Swift. In further support of this hypothesis, Younger also noted a decision in which Cardozo, writing for the court, announced with typical flair that it would not adopt a rule of general common law on the question of whether an insurance policy had lapsed because of a missed premium payment attributable to the insured's incapacitation, rather than allowing the case to, quote, be complicated by a consideration of the court's power to pursue some other course, unquote. Cardozo opted for, quote, a benign and prudent comity, unquote, according to which the law of the state in which the contract was formed would control. More fundamentally, Cardozo was a true blue state court judge. Even after his elevation to the Supreme Court, he was, shall we say, in a New York state of mind. Here it is worth recalling that in the judicial opinion that put him on the map, written while he was still sitting on the Court of Appeals by designation, Cardozo had swatted aside an on-point decision of general law issued by the Second Circuit. Writing for an 8-1 Court of Appeals in McPherson versus Buick, Cardozo declared the old privity rule dead, holding that under New York law, automobile manufacturers owe a duty to consumers to take care that their cars not injure them. Just a year earlier, in Cadillac Motor versus Johnson, the Second Circuit had ruled oppositely on precisely this question and did so relying heavily on New York precedents. In fact, the federal court went so far as to pronounce itself, quote unquote, not persuaded by the contrary interpretation of those precedents that had been provided by New York's Intermediate Appellate Court when it had entertained the initial appeal of the McPherson case. So Cardozo probably took a good deal of satisfaction in demonstrating to the Second Circuit that his appellate division brethren and he had gotten New York law right, thank you very much, and Johnson had got it wrong. Relatedly, Cardozo may have worried that the Supreme Court in Swift had assigned itself and the lower federal courts a task for which they were not well suited. On his understanding, Cardozo's, judges charged with developing the common law were meant to articulate rules that are roughly in sync with prevailing norms and practices. Yet in the Goodman case, to take one famous example, the court, per Justice Holmes, had announced in dictum a hard and fast general law rule according to which a vehicle driver with an obstructed view at a railroad crossing would be denied recovery unless he exited his vehicle to look for oncoming trains. Cardozo later criticized this aspect of Goodman, emphasizing that it had gone astray by adopting a rule without any experiential basis. The Supreme Court, he seemed to imply, was particularly at risk of being out of touch with local mores and hence poorly positioned to fashion common law as he understood it. So the odds are that if he had participated in Erie, Cardozo would have signed on to the rejection of Swift. Assuming so, he and his admirers perhaps have reason to be grateful that he was denied the opportunity to do so. For otherwise, he would have contributed to developments that have brought our courts and our law professoriate to a place that he would not much have liked. If death is ever timely, Cardozo's was timely in that it allowed his professional life to go better than it would have otherwise. Now, I should make clear my aim is not to question Erie's holding. Swift had created serious problems, and it was certainly reasonable for the court to take steps to address them. Still, this shouldn't cause us to lose sight of the fact that Erie has created serious problems of its own. For example, insofar as Erie was meant to block sophisticated corporate actors from repairing to the federal courts to protect their interests against unfriendly state common law, Erie has arguably exacerbated a problem that was perhaps on its way to being ameliorated by other means. Certainly the phenomenon of repeat player defendants seeking relief in federal court from unfriendly state law has not gone away. Rather, it has persisted on different and arguably more problematic terms. Now disabled from inviting federal judges to make general common law, defendants instead argue that federal law outright bars state courts from doing what they have been doing. In particular, starting with New York Times versus Sullivan, the modern Supreme Court has shown itself quite willing to set federal limits on state tort law, often to protect business interests. Unlike the old general law decisions such as Goodman, these decisions are binding on state courts. Thus has Erie substantially raised the stakes for a certain class of state-federal conflicts, and it is hardly clear that doing so has helped level rather than further tilting the litigation playing field. On the question of the constitutionality of the administrative state, Cardozo was of course opposed to the Four Horsemen. Even so, it is difficult to envision him pleased to learn that the duty of vigilance demanded of automakers by McPherson's interpretation of New York common law can, almost at the drop of a hat, be pared down by a federal judge keen to protect the prerogatives of the Department of Transportation and indifferent to the traditional floor not ceiling relationship of regulatory to tort law. At a broader level, Erie has helped to convert the Supreme Court from a court of broad, though not general jurisdiction, into a public law court. The justices now and again take cases that raise common law questions. Thus did Justice Ginsburg and Chief Justice Roberts have occasion in 2011 to tangle over the place of proximate cause in determining liability under the Federal Employers' Liability Act. The vast run of their cases, however, concern questions of constitutional or administrative law and questions about the regulatory state. It is difficult to assess whether the change in case diet fomented by Erie has by itself rendered the justices less attuned to common law and common law reasoning. Over the course of the 20th century, the U.S. Supreme Court and the federal courts more generally have become the focal point of our legal system. By the 1960s and ever since, the big issues, free speech, civil rights, privacy, federalism, were playing out in these courts. By the time I arrived at law school in 1990, the hierarchy of federal over state courts was firmly established. Then, as now, the immediate ambition of many of the most ambitious students, after all, was to obtain a federal court clerkship. Meanwhile, the state courts, though at times still influential, have faded from view. One way to put this point is to pose a simple challenge. Name a sitting high court judge who today enjoys the stature Cardozo attained while on the New York Court of Appeals, or that Roger Traynor attained on the California Supreme Court. Or try this alternative. If asked to nominate a candidate for the best crafted state high court decision on a matter of common law since 2000, which decision would you choose? To be clear, I am not denigrating the talent or dedication of the state bench. I am merely describing a situation that American law and American lawyers now face. Starting somewhere around World War II, the action in American law has been in public law and at the national level. The most perceptive tort scholar of that time, scholars of that time, including the ever-astute William Prosser, saw the writing on the wall. Prosser influentially argued in the 1940s that tort law needed to be reimagined. Instead of being thought of as private law, it had to be seen as law that empowers courts to engage in quote-unquote social engineering. That is, to rule on important policy issues in a manner akin to legislatures and regulatory agencies. This was Prosser's effort to salvage the prestige of a body of state common law, not to mention the prestige of the scholars who wrote about that body of state law, in an age of federal statutes. Ironically, the most influential common law judge of the last 35 years has been an occupant of the federal bench, namely Richard Posner. Quite self-consciously, of course, Posner has claimed for himself the legacy of Cardozo and Holmes. Their greatness, Posner says, lay in their early and clear-eyed recognition that doctrine is the jargon in which judges dress up instrumentally driven policy decisions. This precocious insight, combined with their literary gifts, ensured their enduring significance, says Posner, and by implication will ensure his. Yet Posner misidentifies the secret to Holmes's and Cardozo's success, and his own. What made Cardozo a great judge was his mastery of the common law, a mastery in part constituted by, but hardly exhausted by, his literary talents. Posner's judicial excellence is made of the same stuff. He knows a ton of law. He has an excellent feel for which doctrines are implicated by which facts, and he sees how the law's distinct parts hang together. His distinctiveness, Posner's that is, from his predecessors is largely at the level of theoretical packaging. Turning the tables on Posner, I am tempted to say that he has felt compelled in this, our post-realist age, to hide his common law light under the bushel of law and economics. Anyone who examines Cardozo's decisional corpus will be struck by his opinions with their distinctive sentence structures and memorable epigrams. A closer reading, however, leaves one struck more deeply by his remarkable feel for the subtleties of the common law and their significance. This is a judge who really understood contract, tort, agency, partnership, trusts, restitution, equity, and many other topics for which students, professors, and judges today have little or no feel. This is a judge who saw himself enmeshed in multiple overlapping webs of doctrine and who saw his job as making sense of them, not by reducing them down to a single idea, but by taking them seriously on their own terms, understanding what they mean and don't mean, and grasping how they relate to one another to form a scheme that aspires to coherence and is reflective of, quote, the traditions and conscience of our people. Only a judge who really understands negligence law, tort law, and tort law's relation to the rest of law, including criminal law, could have written Palsgraf. Only a judge who fully grasps the doctrine and spirit of contract law could have written Allegheny College. And only a judge versed in law and equity could have offered the eloquent dissent in People versus Westchester County National Bank. That's the case in which Judge William Andrews, sometimes praised these days for being the anti-formalist justice-seeking champion of the downtrodden Helen Palsgraf, struck down a statute overwhelmingly approved by referendum that authorized New York State to issue bonds to finance modest payments to residents who had served in the U.S. military during World War I. Andrews deemed the bond issue to violate a state constitutional ban on the use of governmental credit to extend gifts to individuals. Cardozo rejected this characterization, faulting Andrews for wrongly excluding a middle possibility between a payment in satisfaction of a legal debt on the one hand and the conferral of gift on the other. The third option, the one applicable to the case, was a payment to discharge an obligation that sounds in equity. Here is how Cardozo described the situation, and I quote at length to remind us of his voice and his methods. This is all a long quote. Great achievement and great sacrifice have been meagerly rewarded. The perils of battle, the hardships of camp and trench may be poorly paid at any price. Few will assert that they are recompensed at the rate of $1 a day. Even for those who did not reach the firing line, there were the pangs of separation from home and kindred, the anxieties and the strain of a new and hazardous adventure. Legislature and people, beneficiaries of this devotion, have heard the call of a moral duty to mitigate the disparity between suffering and requital. But the catalog of suffering does not end with pain of mind and body. There was money loss as well, or so at least a legislature looking at average conditions might not unreasonably believe. We take judicial notice of these things. We take judicial notice, too, that since the beginnings of our history, a sense of the moral obligation to give aid to the returning soldier has been felt and acted on by government. And there's a citation. The call of these and kindred equities have been heard and answered in the past. Are the equities so feeble? Is their summons so plainly an illusion that we may answer them no more? And he continues, we err when we envision the soldier's relation to the government in the category of contract. Contract in the true sense there is none, but service conscripted by the sovereign, and even though not conscripted, rewarded at its will. That is why payment of the wage does not always satisfy the conscience that there has been a payment of the debt. The Constitution does not silence these mutterings of spiritual disquiet when sacrifice unevenly distributed oppresses those who profit by it with the sense of a burden undischarged. Our ruling in matter of Borup was founded in that truth. We held that it was in the power of the legislature by a retroactive statute to assume liability to a landowner injured by a change of grade, though at the time of the change the impairment of value was damage without wrong. Under the law before the statute, the loss was one of the incidents of life in an organized society. It was part of the price which the citizen must pay for the benefits of government. We held that the legislature might readjust the incidence of the burden, might establish a more equitable distribution between the individual and the public through the voluntary acceptance of a liability for a loss which was without a remedy when suffered. I cannot yield to an appraisal of values that would find the basis of an equity there and a mere cobweb, an illusion here. In neither case is there legal liability unless the legislature assumes one. In each, there is an unequal pressure of the burdens and the power of government upon one man and upon others. The readjustment of these burdens along the lines of equality and equity is a legitimate function of the state as long as justice to its citizens remains its chief concerns." End quote. This is vintage Cardozo. Consider how much ground is covered in these two paragraphs. There is an appeal to precedent and tradition. There is a view of the relative position of court and legislature. There is careful attention to distinct domains of law and equity. Note, too, that equity, as Cardozo employs it, is not an ideal of unconstrained discretion to do justice. Rather, it is equity rooted in and constrained by the methods of tradition and sociology. Andrew's majority opinion treated the envisioned payments as a mere act of generosity or as a piece of rent-seeking. Now pause for a moment and bring yourself to the present. Think of the sentiment that is every day expressed when civilians encounter a soldier. "Thank you for your service," we say. This sort of routine ritual interaction is the stuff of equity as Cardozo understood it. The payments funded by the bond issue were no mere gift. At the very least, the legislature could reasonably treat them as the fulfillment of an authentic obligation. And the obligation's authenticity is determined not by high moral theory, but by precedent, by tradition, and by how people in the world actually act, talk, and feel. We have an understanding of military service, an understanding that is practical, not ethereal. It is that understanding that defeats the suggestion that the payments in question had to be construed as mere handouts. Perhaps no generation is entitled to more than a few judicial virtuosi. My worry is that, thanks in part to Erie, future generations will be justified in having even lower expectations. To repeat, my point is not to lament the passing of Swift versus Tyson. It is to raise the possibility that Swift's demise is a tributary, feeding a stream that is slowly leading us away from an accurate and healthy appreciation of common law and common law method. Then again, legal history is anything but linear. Perhaps there is a bend in the river that awaits us just around the corner. Perhaps right now, even as I speak, the next Cardozo is sitting in one of our classrooms. I hope to meet her.
If you want. Feel free to sit there. Feel free to attach something to it. I want to start by saying, as others have, what a privilege it is to be part of this group and to thanking Sam and Turo for organizing this. I can't remember a more pleasurable conference to be at. Like his predecessor, Oliver Wendell Holmes Jr., Cardozo gave his most famous lecture while a 50-something judge on a prominent state court. Both men were recognized as towering intellects on the bench, and both were invited by law schools to hold forth on their philosophical thoughts about law, the nature of the judicial process. Like the path of the law, a quarter century earlier, was simultaneously lawyerly and philosophical, practical and idealistic, progressive and respectful of history. Each in its own way represents a rejection of formalism and a rejection of natural law. Each offers refreshing candor about what is really going on when judges decide cases. And each represents an interpretation of what the emerging American philosophy of pragmatism means for jurisprudence. While Holmes had no tort case as famous as Palsgraf or McPherson and did not make the kind of mark on Massachusetts law that Cardozo did in New York, he of course had a more illustrious career as a Supreme Court justice. Moreover, it's probably fair to say that his concision, his cynicism, and his wit have captured more minds in legal theory than Cardozo's magnetic moral prose. Indeed, some would say that that is an understatement, for Holmes's prediction that the man of economics is the man of the future has been realized, and the seeds of legal pragmatism planted in the path of the law have grown into forests. We've heard relatively little of the method of sociology in the legal academy over the past century. In short, Cardozo's jurisprudential musings have plainly lagged well behind Holmes's. Cardozo's finish behind Holmes in jurisprudence is unfortunate, undeserved, and ironic, I will argue today. It's unfortunate because I think both our legal system and our political system would have fared better in the reverse scenario in which Cardozo's ideas moved legal thinking more than Holmes's. It is undeserved because I think Cardozo's ideas were deeper, more interesting, and better developed than Holmes's. And it is ironic because although Cardozo was more modest about his philosophical capacity than Holmes, his form of pragmatism lies far closer than Holmes's to the most sophisticated forms of pragmatism that ultimately developed through the 20th century and today. American pragmatism sprouted from the mind of Charles Sanders Peirce in mid to late 19th century and was taken up and transformed in different ways by Peirce and several other great American thinkers. Its most famous exponents, each with his own transformations, were William James and John Dewey. As chronicled in Louis Menon's book, The Metaphysical Club, Holmes was an intimate part of this group and was taken with its ideas. Several contemporary scholars, including Judge Richard Posner and Professor Tom Gray, have offered powerful and highly plausible descriptions of Holmes as a pragmatist. Moreover, there is much to be said about how Holmes's form of pragmatism nicely prepared American legal thought for legal realism. The pragmatism of Peirce, James, and Dewey, while different in numerous respects, shared at least the following ideas. First is a strong epistemological ethic of fallibilism and experimentalism. When we as human beings think of our capacity to know what is in the world, we must be aware that we could always be wrong. If I'm wrong, I will learn by tripping over reality, on the pragmatist view. That's to say, the practical tasks of getting through whatever it is I need to get through in life will send me the message that some part of my belief set is wrong. There's a forward-looking side of this epistemological ethic. It recommends experimentalism as a way of learning. But because pragmatism is all about how well ideas succeed, experimentalism has both an academic and a non-academic side. Trying new ways of doing things, of living life, is part of becoming more knowledgeable about the world. Second, at a profoundly challenging metaphysical level, is an approach I will call holism. I'm enumerating these three features of philosophical pragmatism. The holism I have in mind states that it's somewhat misleading to talk about testing a hypothesis against reality to see whether it is true, because we can only test a hypothesis against a background of other statements that frame it. So in a sense, we are comparing our whole bundle of beliefs and commitments against the world of experience as a whole. But the holism of Peirce, James, and Dewey drew profound implications from this. Each was suspicious of the fact-value distinction, and each suspected that our subdivisions of various areas of thought were themselves temporary and elusive. That's why James was a pioneer in thinking about religion, psychology, and many other areas, and why Dewey was even greater in his breadth. Finally, just as fallibilism is also in part experimentalism, this holism is in part what I call, not very eloquently, anti-representationalism. When we experiment, we are not just checking to see whether some hypothesis or picture of reality matches reality in the sense of looking like it or representing it properly. We're asking what it means to live with those beliefs. We're asking how things will work out in practice when we go around having those sets of beliefs. Okay, the third facet of this philosophical view tempers the huge ambition of holism and anti-representationalism by adding to it an incrementalist methodology and a humanistic mindset. We test hypotheses one at a time because the predicament of being a knower in the world, to follow the philosopher Otto Neurath, is like being in a boat at sea. The boat constantly needs repairs, but one can only repair the boat one plank at a time, because one can never get to dry land to do the repairs, because knowing and understanding are essentially linked to acting and responding. One cannot afford to change in a radical way all at once. Contemporary scholars of Holmes, especially Tom Gray, have brilliantly displayed Holmes's jurisprudence as an adaptation to law of many of these pragmatist themes. Holmes clearly thought societies were fallible, and he embraced the modernist mindset of demanding improvement and change by trying to do things differently. His tendencies toward the embrace of holism and anti-representationalism are surely evident in many ways. His statement that the life of the law is experience, not logic, that's not simply an expression of empiricism, but of this holism, in a way that is most important about the answer is not the answer that experience is not logic is the life of the law, but the question, what is the life of the law? Here we have an anti-representationalist, someone saying that the rationality of inquiry in law is all about how well it is working, not whether it gets the right snapshot of some underlying transcendental normative reality. Finally, Holmes's love of the common law and his work as a judge displayed his fundamental commitment to incrementalism as a way of making progress. Now, before I return to Cardozo, I want to follow out the arc of legal pragmatism in the first half of the 20th century. As I see it, at least two strands of thought were developed out of Holmes's pragmatism, each with a claim to be Holmesian. One dwelt on the pragmatist emphasis of action over representation, and looked at law principally in terms of what was done, not what was said. Courts, judges, actors. This is, of course, standard legal realism of the form that morphed into law and society, and in many ways, the social, scientific, and economic study of law. Another strand dwelt more on the idea that systems of words and language often conceal a huge set of social purposes and goals that are actually being pursued indirectly. Combined with an operationalistic and reductionistic approach to language that was also ascendant in the early 20th century, Holmesian pragmatism quite naturally turned into a form of instrumentalism in law. We see in Richard Posner's Law and Economic Analysis a resynthesis of the social scientific and the instrumentalist strands of Holmesian thought, all with the goal of efficiency. So where is Cardozo in all this? This is not a Holmes conference, but a Cardozo conference. I need not spend much time convincing you that Cardozo was a pragmatist in the respects I've indicated. It leaps off the pages of the nature of the judicial process that he was a fallibilist about judges and about our legal system's ability to get the law right, that he thought courts must try to move the law forward and see how various changes will work. I'm sure you will also agree with me that in showing us all the different methods, philosophy, history, tradition, and sociology, Cardozo was a great holist about legal thought and about thought more generally. And we could all find hundreds of places where he emphasizes how important incrementalism is as a judge. In these respects, Cardozo, even more than Holmes, was a wonderful exemplar of these key features of American pragmatism. And yet, if anything is clear about Cardozo, it is clear that he did not accept either the social scientific form of legal realism that takes action to be the essence of law, or the instrumentalism that treats words as elaborate covers for utility maximizing social devices. Why not? Why didn't he accept these two strands? My own view all along is that Cardozo rejected both of these approaches, not just because he was too good a judge, but also because he was closer than Holmes to understanding the most sustainable form of philosophical pragmatism. Cardozo never believed that the language of the law was just a shell for brute policy judgments, or that it was just window dressing for political acts judges were motivated to perform. He believed that part of what the law is a set of ideas with their own content and structure that judges recognize and implant through words. Here is what he said as to the action side of legal realism in his address on jurisprudence to the New York State Bar Association in 1932. I quote, "Fundamental in the thought of the neo-realists," by which he meant the realists, "is the exaltation of what is done by a judge, as contrasted with what is said. They cling to the motto that actions speak louder than words. Indeed, they go beyond it. For some of them seem to tell us not only that conduct is the louder, but that words do not speak at all." Cardozo could not have been clearer in rejecting this view. I quote again, "If I consult my own experience and ask what judges do in building law from day to day, I find that for the average run of cases, what our predecessors have said is a generative force quite as much as what they've done. I do not mean that what has been said by way of mere dictum, though I have no doubt that even dicta have been propagating forces and have borne a fruitful progeny. I mean what has been said as the professed and declared principle dictating the conclusion." This passage tells us why Cardozo was not a reductive instrumentalist either. The generative force of what is said in the law stands in marked contrast to the reductionistic view that legal terminology is just a placeholder. Language and the body of law containing that language do not merely register the policy judgment at which the law has arrived. Language contains, for lack of a better term, the wisdom of the law not yet fully formed. Like Ronald Dworkin, another Jewish-American jurisprudence scholar who expressly drew from him, Cardozo insisted that principles were not just important to the law, but were actually a critical part of what constituted the law. I quote, "Certainly the historic masters of the law have been boldest in the pursuit of principles," he wrote, and then adding his pragmatist spin on this critical point, he said, "Though this is not to say that they have not also been bold in rejecting what has proved itself to be outworn or untenable." Unquote. Cardozo believed that to understand law is to grasp it as fully integrated into our history, customs, traditions, and society. He was, like Holmes, a pragmatist in law. Yet, unlike many of Holmes's followers and many of the legal realists he criticized, Cardozo treasured the language of the law, a point nicely made by John Goldberg in his Law Review note almost 30 years ago. I would add an important philosophical pragmatist spin to this recognition. Although Cardozo, like the realist, saw experience as the life of the law, he did not see language and thought as alien to experience, but as part of experience. The irony with which I began and to which I now return is this. Philosophical pragmatism in the past 100 years has gone through many phases too. During the early part of the 20th century, the pragmatism of Dewey and James was sometimes regarded by many philosophers around the world as something of an embarrassment because of its lack of rigor and its reductiveness. Then parts of pragmatism broke off into social science, and parts of it combined with highly structured forms of logical empiricism. But by the mid-20th and especially the late 20th century, the pragmatism of Willard Van Orman Quine, Wilfrid Sellars, Hilary Putnam, and Richard Rorty came roaring back and now holds great esteem in both analytic and continental philosophy. And it did so by working with the complexity and generative power of language in our society, not against it. That's what Cardozo knew all along. Thank you.
One of the wonderful things about the Jewish tradition is no matter how often you repeat a ritual, it in some sense gains strength through repetition. So let me repeat our ritual thank you. to the Jewish Law Institute, to Sam Levine, to all of it for just an absolutely wonderful conference. Now, Nixon versus Condon has a familiar feel to it. Dr. L.A. Nixon of El Paso, an African American, spent a decade trying to vote in a Democratic primary. The first time he tried to vote, he was told he couldn't because Texas had a law, a state law, saying no African American could vote in the Democratic primary. That went up to the Supreme Court, and it was killed, said this was a violation of the 14th Amendment. Texas, being nothing but creative with respect to race relationships, then passed a law saying that the executive committee of all parties would decide who would vote in what was undoubtedly the least surprising news item of 1930. The Texas Executive Committee of the Democratic Party said no African Americans can vote. Nixon tried to vote again and was told he couldn't, and the case comes before the Supreme Court. And the Supreme Court divides 5-4. The 5 justices in the majority, Cardozo, Brandeis, Stone, Hughes, Roberts, have collectively become done. Collectively, now we know in the scientific term, the good guys on the court. They vote to declare the law unconstitutional. In his first majority opinion on the court, Cardozo says, since Texas designated the executive committee of the Democratic Party as the body entitled to determine who would vote, that body became a state actor. Therefore, given the Constitution says no state may deny equal protection, the Texas Executive Committee denied equal protection. It's unconstitutional. The minority, McReynolds, Sutherland, Butler, Vandevanter, known under the scientific name the bad guys, said, in fact, the Texas Executive Committee had been making these decisions all along. Who cared one way or another? And they dissented. Now, the way we often teach Nixon is part of the baby steps the Supreme Court took on the road to Brown versus Board of Education, that this was liberals beginning to understand that racism was wrong, that courts were the heroes in the fight against Jim Crow. And to some extent, it was a theme yesterday that Cardozo in our time, so there were fights in our time, and to a large extent we asked, what would Cardozo do? And what I want to do is, typical historian, is historicize. And I want to suggest that, in fact, when we look at Nixon versus Condon and Cardozo, we see strangeness, but perhaps a strangeness we can learn from. So the first thing that might have set us wondering is, it's strange for liberals to be cheering Nixon on. 50 years, right? 50 years later, we knew that when Nixon was a litigant, we wanted the case to go the other way, and not simply Richard Nixon, for those who know our political question doctrine, Walter Nixon, the crooked judge, who the Supreme Court said we would not interfere with his impeachment. But it's not simply the name. It is rather remarkable that Cardozo's career on the Supreme Court begins with a modern-looking civil liberties case, Nixon versus Condon. The opinion he ends on Polko versus Connecticut is a civil liberties case, and there is almost nothing in between. And part of this is the court's docket. The court's docket, until the 1940s, 1950s, was almost devoid of the cases we now teach in Con Law 2, civil liberties. Virtually everything, if not a common law case or a diversity case, dealt with the powers of the national government. There were no civil liberties courses. Nowadays, we have, say, a two-semester con law class. The civil liberties textbook is like this. The powers in government textbook is like this. And the only way we can teach the class is we move part of civil liberties into con law 1. If you look at the classic text, to take a couple examples, Joseph's Story, 10% of commentaries on the Constitution is devoted to what we might barely call civil liberties straining. With Thomas Cooley, it's about at 20%. It's a different world. And if we look at Cardozo's opinions, what did Cardozo spend most of his time writing on? An amazing number of bankruptcy cases. Unsurprising, given the New Deal. An amazing number of tax cases, both constitutional, could we apply this tax, and simply, well, did this person pay the right tax? Indeed, a fair number of admiralty cases. Indeed, if you read the Supreme Court, from the time Cardozo was on it, you would be convinced that the problem of negligent treatment of sailors who became sick at sea was far more a national crisis than the problem of African Americans whose rights were violated in the United States. And by the way, you would probably surmise from your biology class and various other things that there were women in the United States at the time Cardozo was on the Supreme Court, but you would find no evidence of this in any of his writings. And the pattern of Cardozo here is fairly well known. It's deference, indeed, one may argue, that most of Cardozo's opinions in this time looking for someone to defer to. Cardozo deferred to Congress. Cardozo deferred to states. Cardozo deferred to administrative agencies, though unlike the next generation of New Dealers, it was not automatic. There always were limits. States could go too far. There were limits to the commerce power. Administrative agencies could make mistakes. When administrative agencies made arithmetic errors, when administrative agencies failed to consider depletion, Cardozo said, you have gone too far. Moreover, what is interesting is the total absence of democratic justifications for deference. It is rather interesting that the first time a Supreme Court opinion, a majority opinion, says the United States is a democracy and that's a good thing is 1939, a year after Cardozo left the court. Brandeis, the ideologue, is the first justice ever to speak of the United States as a democracy and this is a good thing, and Cardozo does not join those opinions. Cardozo, instead, and I think Benjamin really helped me understand, the virtue of legislatures, administrative agencies, Congress freeing them up is experimentation. This is where we could have social science. This is where we could have experimentation. They needed flexibility. So that was his deference. Second reason why Nixon versus Condon is unfamiliar to us is, in fact, Nixon is a part of an older way of understanding race, one that commanded the entire court, and one I believe Cardozo participated in. And we need a little background here. Most of us understand the era from 1880 to 1940 is the era of segregation, of Plessy, and other horrors. And there was a tendency for people to understand courts saw a person of color and just said, voted against. But in fact, Plessy is a legal regime. It's an evil legal regime. But just as it turns out in the evil regime of slavery, slaves who acted as good slaves actually won cases against masters who acted as bad masters. African Americans could win cases. It's a wonderful book by Julie Novkov on the way Alabama courts adjudicated miscegenation cases, cases in which people were accused of having mixed race marriages. And it turned out, unsurprisingly, if you attacked the law itself, the court brushed it off. But there was another attack you could make. You attack the facts. We're not a mixed race couple. And it turned out the decisions are, well, we can usually tell a white person and an African American by looking at them. So can we get witnesses who look at them? And that was our way of telling race. But by the way, the Alabama court, one in about a 20-year period, killed half of the miscegenation convictions it got on hearsay grounds. Aha, I testified that Bill told me that this person was a person of color. No, that's hearsay, out-of-court statement being used for the truth of the matter. Little things you learn teaching trial advocacy. And what was interesting, even though it seemed fairly clear we had a mixed-race marriage here, if you proved it by hearsay, the Supreme Court of Alabama, at the turn of the 20th century, killed it. In other words, within this very evil rule, they operated as a normal court. And then we move to a case, U.S. versus Bhagat Singh Thind, 1923. Before Cardozo joins, it's unanimous. The issue is whether a person from India is white for purposes of immigration. Because if you recall, at this time the law was very clear, no non-white person could become a naturalized citizen of the United States. Justice Sutherland delivers the opinion, it's unanimous, and the big issue is, well, by common knowledge, people from India are not white, but it turns out there's lots of research that actually shows they really are white. And it turns out common knowledge wins out, but what to me is more interesting is there is not a peep from Brandeis. There is not a peep from Stone. There is not a peep from anybody. And there's no sense of, there's no sense that anyone has, like, we're doing a really funny exercise here, trying to figure out what race somebody is. Not a peep. 9-0. This is the world Cardozo inherited, and one case highlights how that world worked. It's a case called Morrison versus California. And I always risk talking about Cardozo cases with Professor Kaufman in the room, who has forgotten more than this than I know. And one should say for every talk here, he should feel free to interrupt and say you're just getting the whole thing wrong. But deals with the California alien law. California forbade aliens from engaging in agriculture, owning land and farming on it. And when Morrison and Doy were arrested, indicted for a conspiracy to give land to an alien not eligible for citizenship for the purposes of agriculture. Cardozo writes the opinion And I want to highlight for you just in some ways how alien it is to us. It is unanimous. Nobody has a fuss. We start with citizenship, and Cardozo begins with birthright citizenship. So in fact, if people are born here, it doesn't matter if their parents are ineligible for citizenship, they are citizens. We know some of the controversies over that today. We also has no problem with no naturalization for non-whites. That's the law. Not Passover, not a problem. And now there's an interesting problem. How do we know whether someone is non-white? He goes back to Begat Singh Thin and said it's common knowledge. So particularly, what about a person who's half white, quarter white? He says, common knowledge, they're not white, might even be less. That's not an issue in this case. Well, California law worked in an interesting way. Namely, once the state proved you were non-white, the burden shifted to the defendant to prove they were a citizen. Now notice the potential constitutional problem, and this is what this case is going to turn on. It has nothing to do with race. The question is, under the 14th Amendment, in a criminal case, can you ever shift the burden to the defendant? And Cardozo says, I've got no problem with that because why? Well, it's hard to prove whether as a person is a citizen. They know it. They have the information. So once we prove their race, it's perfectly okay to shift the burden. But it gets trickier because we have Morrison and Doi, and as the name might give you, Morrison everybody agrees is white. Doi everybody agrees is Japanese. And the problem is Morrison is in a conspiracy with Doi. Can we prove Morrison guilty? And there he says the burden shifting doesn't work. Why? He says, well, how do we normally prove race? We look at people. That's our standard way of proving race. But Morrison may never have looked at Doi. We don't know. Therefore, the burden shifting is unfair in this case. And therefore, Morrison is found, or the case is remanded, the conviction is tossed. Now, there's a lot more to this case. Notice, by the way, it is 9-0. So it is not simply, you can't interpret it as Cardozo really thinking, okay, all these laws are rotten, but I can't get around them. I'm going to get out this kind of technicality. McReynolds entirely agrees with all the burden shifting analysis. The most conservative justice, the biggest bigot ever to sit on the Supreme Court, he's got no problem. That 1934, a case everybody today would regard as a race case, Cardozo and everybody else treats it as burden shifting. There is no sense of courts as leading the fight for racial justice. There is no sense of courts as liberal heroes, except to the extent that courts can free politics so the liberal heroes in politics can function. So if we want, who are the liberal heroes of the time, it's probably La Follette. And I'm getting a stop, so if I can get about a minute. Now, what is interesting is now our liberal heroes are judges. Ginsburg, Kagan, Sotomayor is campaigning to be a liberal hero, as Scalia campaigned to be a conservative hero, but they have something in common, I will submit, with Cardozo. We've talked a lot about the nature of the judicial process, but Cardozo never talked about the nature of a political process that could produce judges who could act consistently with the nature of the political process. We now talk a lot about liberal judicial heroes, but we rarely talk about the nature of a political process that produces liberal judicial heroes. Liberalism at its beginning did not have an adequate theory of politics under Cardozo, and we still don't. Thank you very much.
We have time for one quick question. Do I have a?
Not to a lot.
Yes, please.
Possibility in the sense that you sort of conceded that you lumped the philosophical pragmatists together. You could say James had a greater influence on Holmes, and Dewey had a greater influence on Cardozo, and it was the participatory democracy ideals of Dewey that Cardozo adopts in this kind of way that Mark has suggested, reference, that would tie into your notion of Cardozo's seriousness of language and civility. Is that possible? How do you account for Cardozo's sort of deviation from the standard philosophical practice?
Well, I don't have a very good answer, but I have a slightly cute answer. So, first of all, I'm going to think more about the connection with Dewey because I've been focusing fairly intensely on that New York State Bar Association address. And he does talk a lot about Dewey there. So that may be part of it. I tend to think of Dewey as, in a sense, further away from the kind of pragmatism that is ascendant now, even further than James. And I think of the founder of pragmatism, Charles Sanders Peirce, as the closer one. The sort of cute answer is one that I slightly intimated by referring to Dworkin as another Jewish academic. I do think that there is something about, and maybe partly that I'm here, I don't know, at Touro, but there is something about the love of the word and sort of the idea that you would exclude the word and the language and the thought from your study of from your study of life and from your practical study of what to do. The idea that you would exclude that rather than make it central is totally alien to somebody raised in a Jewish intellectual tradition. So that's my sort of causal explanation.
Well, thank you so much, John, Ben, and Mark. Thank you.
I wish we had more time.
Yeah, nice sound. Really interesting.
Yeah.
Thank you, Joan.
Okay, welcome back, everyone. And thank you again for another terrific panel to lead off things. And on the heels of that wonderful panel, we have yet another excellent set of presentations coming up. And it's my pleasure to introduce our moderator, Larry Rafel. Larry is our former dean here at Touro Law School. And I want to take this opportunity to thank Larry for all the years of support of the Judicial Institute in his capacity as dean and continuing since Larry has returned to the faculty, continuing to be very involved in all of the activities of the Jewish Law Institute.
Thanks, Sam. Well, ladies and gentlemen, boys and girls of all ages, we finally arrived at Paul's Graph. I'm sure that you're so excited. It's taken a year, taken a day and a half for Sam to figure out that the reason people came is to talk about Paul's Graph. And what was Mrs. Paul's Graph with all the kids, and what was in the package, and who were the Italians? I was thinking, like, who are those Italians? A little bit racist in that, but anyway, we're fine. And of course, I'm sorry to say that every time I sit on the Long Island Railroad, I still think about it. So it's a curse. You know there is a Paul's Graph curse, right? That's very famous too. So anyway, we finally get to Paul's Graph, so that's good. We have this wonderful panel that I'm pleased to introduce. I guess we might as well speak in the order it is, which gives me a chance to introduce John Diezenkowski, which for me is a personal pleasure. No offense to the other two, but being in the legal ethics area since for a while, 76, John. I've been teaching PR. I've read a number of wonderful pieces by John. I use his textbook today, and I've used it for a number of years. I finally figured out that Morgan and Rotunda had no idea what they were talking about, so I moved to your book, and it's been a pleasure to use his work with my students, who I think have benefited from his clear and concise writing. So, John, it's a real pleasure to introduce you, and you're going to kick it off.
Thank you so much. I'd like to start, of course, by saying these two conferences, Brandeis and Cardozo, are just terrific. Thank you, Sam. Thank you, Toro. It's a pleasure to take the work of one individual and to look at it through so many different lenses with so many experts. And it's really a wonderful experience. And many of us go to a lot of conferences and they try to do too much, but these are just beautiful. Some of you may be wondering, what am I doing here? Where's this legal ethics person? Why am I here? Well, when Sam called me, I said, I'm going to do a little research. I'm going to find a topic here. And of course, on one hand, I said, there might be some legal ethics opinions. There might be some discipline things that I could find for Cardozo. And I found a couple, but not enough to really give a talk on. And then, of course, clerking for Judge Keaton had written a book on judging. I thought about doing that, but other people were doing that. So I went back to my roots. So I have an undergraduate background in accounting. And when I was in law school, I chose a note. And at that time, the AICPA had come out with a little less than an audit, a compilation and review. And people weren't doing these because they were worried about the liability. And I had worked a little bit for Knight Ridder newspapers, and I knew a little bit about compilation and reviews. And I said, I'm going to write about accountants' liability. And so, of course, in that area, looking at ultramares, looking at the expansion of tort liability of professionals, that was sort of my first foray. So, of course, that's where sort of I start here. Then in teaching and learning from the teachers at Texas, Paige Keaton, studying, of course, some of the works of Leon Green, and then clerking later for Judge Robert Keaton. So Judge Keaton was very, very famous for two things. He forced lawyers in all types of cases, civil and criminal, to look at duty and causation. And sometimes the lawyers would say, Judge, we've conceded that. We'll concede that. And he would say, no, I want you to talk about the duty. Where does the duty come from? And they would always frustrate some of those lawyers. If you read some of the reviews of Judge Keaton, they would say, distinguished jurist, but a little too academic. And of course, that was what happened. So here I am talking about the liability of professionals and Cardozo's use of privity. I do this, of course, recognizing that there are a half dozen people in this room who have written beautiful works on the history and jurisprudence and in these areas. I cite a lot of that stuff, but of course it's very difficult to cover in these few pages. So I want to start by saying that I look at the way Cardozo used privity and duty as key concept in this third-party liability area. And of course we have the development of the tort law in the 1900s, the importance of the cases, how common law judges were real change agents forced with deciding cases that helped create precedent that then developed the law. I believe that judges that used a more doctrinal approach, that cited cases and distinguished and created a traditional general rule exception, had more influence. The courts were more persuaded. They gave blueprints for lawyers to look at this work. And in part, Cardozo was a sort of a paradigm of a judge who took advantage of that. And as Professor Kaufman mentions, a lawyer first, and somebody who understood lawyering and understood arguments in contract, arguments in torts, arguments talking about defenses. And so that was, I think, in my mind, very important. Of course, New York being a central area of commerce, the court being so important, and many people, of course, have written about that, in the ideal position, the ideal judge, with the ideal facts. So the facts of cases that he got, I don't know if they were as clean when he got them, but when the opinions came out, the facts were narratives. They were very clean. They were really well and easily understood and easy to persuade. And so in some ways, Judge Posner talks a little bit about the persuasive narrative approach. So in my mind, Cardozo used that in a very effective way. The use of duty and privity and the analysis that he made in the cases, and I'm only going to talk about a couple of cases. There are many we could talk about in my piece. I plan to talk about more, but he really did have a construct of analysis that made it easy for people to understand where he was going. He was really bringing it away from general concepts, general sort of foreseeable liability, for harm and risk, and putting it into duty, and then, of course, using the privity concept. I believe that ultramares and the privity point has a lot to do with even the exceptions today that were carved out, because courts had to struggle with that and overcome that. And so as you have the exceptions that have developed, the third-party beneficiary rule, the rules on foreseeability, and I expand upon that more, but that I think that the privity concept forced them to address that. I do believe that what was going on in society at the time was very important. Talk about that a little bit. He does not explicitly mention those developments, but I think they had to have a lot to do with it. And of course, the stock market crash of 1929, the crisis of accounting, the need to develop a profession, the need for accountants to know how much to test. And when you read Ultramares, it's very interesting to watch him talk about what did they do, what would they have done sampling and random sampling of items that could have gotten toward this the problem. I do believe, of course, that the narrative, the analysis, the prose, the quotable language, all are relevant to why these opinions are relevant today. And it's a testament to his work. Now, of course, any analysis of privity would begin with the 1942 Winterbottom versus Wright decision, where you had a stagecoach driver who's injured when a stagecoach collapses. You, of course, have the court using privity to bar recovery from the manufacturer. And you have the United States Supreme Court in a lawyer case where a lawyer looks at a title of a certificate and negligently prepares it and issues the certificate, and a third party a bank cannot recover from that lawyer because of the problem of privity. Now, from those early cases, you still had in the National Savings versus Ward case an exception for fraud, collusion, or privity of contract. And of course, it led the opening, of course, for the cases to take and use those constructs. When you had third parties, you had this strand of cases, some, of course, physical injury, as you have in Winterbottom versus Wright, some financial injury, which, of course, you have in National Savings versus Ward. There's some fascinating scholarship on economic versus physical, and you have a separation and then kind of a confluence, and so you have similar constructs used with different harm, and yet it's something that, in my mind, creates a very interesting sort of an analysis. Now, why was privity used, a contract term, in a negligence torts case? And there's an article by Vernon Palmer in a history review that talks about when people tried to recover on multiple theories, recover in contract, recover in tort, that's when the transfer, the concept of contract moved into tort, and the concept of the exception. So if you had privity of contract, it would offer this extension of liability to third persons. And so it's sort of a very interesting history, but that the privity was set up, of course, as a major bar in this way. Now, when you turn to McPherson, and of course, many of you have written about McPherson in sophisticated ways, you have Cardozo taking the privity concept and basically saying, because of New York precedent, because of a dangerous product case, we are not going to require privity when a purchaser of a car from a dealer sues the manufacturer, even though they're 2 steps removed, to recover in negligence. Now, part of the background in the history when you look at this time was the dramatic expansion of the number of cars in the 1900s. So you have in 300 cars in 1895, going up to 78,000 in 1905, going into almost 500,000 in 1910. Then by 1914, 1.7 million cars. Now, those cars were not constructed by 3 or 4 car makers. There, in fact, were thousands of car makers in the United States at that time. Now, again, these are not mentioned in the opinion at all. I'm just talking about the background that I think when you have hundreds of thousands, possibly, of cars in New York out of those 1,700,000 on very few throughways. I read that Buick advertised you can go 50 miles an hour in that car. And then you have a lot of deaths mounting. This has to be part of the context of deciding this case. Now, Cardozo, of course, is faithful to the law and the precedent. It is crafted in a very meticulous way, citing cases, quoting from cases with parentheticals. And using that dangerous, inherently dangerous instrumentality concept from that one earlier case dealing with a drug, using that, but not so broadly that it makes everything a dangerously inherent product, but to look that if you're negligent in constructing a car, that it is foreseeable that it will be inherently dangerous to third persons, to the driver, to the person who purchased the car. Now, Cardozo might have said, instead, he might have said, we don't need to go this route. We don't need to get rid of privity. We could just say, we will collapse the transaction, and when you purchase from a dealer who purchased from a manufacturer who purchased components from the wheel maker, that is all one transaction. He could have possibly done it in contract. He could have done it and strung those together. But instead, he chose this route. And this route, of course, has been interpreted broadly, and I know 2 in here have written too broadly in many respects. But this did help create the foundation for products liability, and it helped create the foundation for creating safer cars, and helped create the foundation for having a sort of third-party suit in a products case, in a case involving a product. Now, I find it fascinating that there was this Second Circuit case decided a year before McPherson, where they followed Winterbottom versus Wright, and they reversed a judgment against Cadillac. But then a year later, as the case was retried on some other issues, when it came up to the the circuit adopted Cardozo's McPherson position. So you had the Second Circuit with discretion to use persuasive opinion, changing its view within such a short period of time. And of course, I know Cardozo enjoyed that and relished that a little bit later on in a lecture, but it was one of those things that this formed a sort of the beginning of the erosion in this area for him. We have the Glanzer case that involved a weigher who weighed some beans and created a certificate and then gave the certificate from a contract from the seller to the buyer, and they negligently weigh the beans. And so the question is, can the buyer sue that weigher? And Cardozo says, yes, clearly, the certification of the weight is relied upon, and it's done for both parties. It's really done for the seller of the beans and the buyer of the beans. And it's one of this thing where people were afraid audited statements are certified statements. And as this case forebode that when you certify financial statements to third persons, all of a sudden you have a broader liability. So there's no doubt that Glanzer formed an argument for expansion of liability against accountants for third persons. Now, Cardozo didn't view this as an exceptional case and establishing any new principles. He viewed it as the equivalent or approaching privity. And so it was simply an elaboration of a concept. Now, just think of at the time when commerce grows exponentially and weighers become very important and instrumental. Now, they were always important, but you can just see the wheels of commerce turning and the need for weighers to exercise care. And of course, the liability in negligent weighing is the value of the error you made. So it's an ascertainable and foreseeable error. If you say there are too few beans and someone buys them and doesn't get the quantity or weight that is believed, of course, that's the range of harm and damage. Now, in the Ultramaris case, you have a case where a client hires Touche, accounting firm, to prepare audited financial statements, and many copies are produced and given to the client, who then hands them to other parties. And a bank gives money based upon the financial statements, and it turns out they were negligently prepared. And Cardozo, looking at this case, doesn't really go and is not as tempted by the expansion. He's going back to privity, and he's going back to the idea that we need some connection between the third person suing the accounting firm and the error. And in this instance, you have, this does not apply when you have privity. This does not apply in a case of fraud. And the case is actually sent back for fraud. But his work and the statement that the work was primarily done for the client, and the accountants didn't know to whom the statements would be shown, for what purpose would they be shown, for investment, loan, or equity, or purchase of assets, to what extent, how much would people pay and rely upon those statements versus doing an independent investigation. And of course, we had at this time the financial crisis, the Congress holding hearings at the Securities and Exchange concept that we, of course, need new laws in the 1933 Securities and Exchange law coming into effect a couple of years later. The importance of the accounting profession that, of course, had come to its own in the mid to late 1800s, particularly in England, but really needed a boost. And so in this instance, it is foreseeable that the statements will be shared, but the other aspects of the foreseeability are not there. And so Cardozo picks the bright line rule of requirement of privity or fraud, sends the case back for fraud, And it's very telling that he mentions the legal profession and how lawyers would be responsible to third persons. And it's very telling that he mentions the title industry and other professionals. Now, of course, this, has been the rock for accountants and lawyers in many subsequent cases, in trying to show that your duty is primarily to your client and not to the third person, and that any expansion of liability creates problems with that original relationship, as well as with how expansive and extensive the liability becomes. Now, when you look at the opinions, of course, we've all discussed the last 2 days, the idea of his narrative was very clear and precise. It was eloquent and powerful. He articulated the doctrinal work and particularly duties and harmonized the precedent. He focused on majority rule and exceptions, and even mentioned exceptions when they were not relevant. When you look at developments in society, he mentions them, but this is not, I am not a legislator changing the law. I'm applying the law to new settings. And so if today he were around and the cases involved bioethics, he'd be applying the law to new settings, to new situations, such as doctors' obligations in the bioethics area. In this instance, there's no doubt that I believe in the 3 areas. In products liability, Wright became a very important case. And it accelerated the development, although it is claimed to have done much more than it actually did. But it was very, very important. And I believe that it had an incentive on automobile safety. The car manufacturers spent a lot of time fighting these cases. When they started to lose the cases, of course, it became a real risk that they faced in producing cars, and so safety became more important. For the accounting profession, it really improved the whole idea of what standards should we have to gain accuracy, what is important for confidence of the profession. They experimented with a lot of the things that Cardozo talked about in terms of sampling of entries and how much would be required and what would be, and how you would take statements. So from the accounting profession, there's no doubt that it did give them time to develop stronger professional standards. And in the tort area, for liability for professionals like lawyers, architects, and others, the duty analysis and the foreseeability of risk analysis still are extremely present in the constructs that current judges have done. Now, I'm going to go ahead and stop here. I've got another slide, but I'll stop and thank you so much.
Thank you so much, John. Before I introduce our next speaker, I did want to take the privilege of the chair, in case you haven't met him yet, to introduce my predecessor, Dean Emeritus Howard Glickstein, who's with us yesterday and today. And he's really the architect of the modern Touro Law School, serving as dean for nearly 18 years. 18 and a half years. Howard is a hero of the American Civil Rights Movement. He was at the Department of Justice working on the 1964 Civil Rights Act and the 1965 Voting Act, and if you have a chance to say hello to him, you should, because he's a wealth of information. And I think went to school with Cardozo. Was that? I could be wrong on that. I'm not sure. Anyway, it's wonderful to have him here. So, our next speaker, you want to go next? Good. Our next speaker is Michael Green. Professor Green is the Bess and Walter Williams Distinguished Chair, which I think is a lovely title, at Wake Forest University.
I negotiated that.
What's that?
I negotiated.
Oh, you negotiated. Well done. Well done. At the Wake Forest University School of Law, Professor Green.
Thank you. When Sam first contacted me about coming here for this conference, he told me about what a splendid group of people he had assembled to come and talk. And then he said, I've got 2 wonderful people on this panel about Cardozo and torts. He said, I need one more person who knows something about Cardozo and his work. And an odd moment came over me. I said, oh, Sam, there's probably one or two other people that could do a better job of that than me. It was brief. Sam responded and he said, one or two? Mike, there's dozens, but every one of them has turned me down. So I come here with my ego quite deflated about talking. I then found another concern. I started thinking about Cardozo after a research assistant prepared a bibliography. And I realized what I'd gotten myself into. There are 6 books about Cardozo, including Andy Kaufman's definitive biography. There are 5 books by Cardozo, 4 that contain his lectures that were written up, and 1 about New York procedure that he published before he went on the court. There's at least 3 symposia, including this one, that were devoted to Cardozo. Countless articles about him, about his opinions, his rhetorical style, his views and lectures about jurisprudence. And I despaired of having anything new to say about Cardozo. I read more and I realized that each of our predecessors who addressed Cardozo were influenced by their own vision, values, biases, and interests, a product of the total push and pressure of the chaos, as William James put it. And so I think I have something to say. I'm a torts teacher. I fervently believe that to understand U.S. tort law, one must understand the respective role of judge and jury. I spend a lot of time beating that into my students when I teach them torts. I also believe that modern tort law is significantly shaped by the fact that we have a jury deciding the vast majority of tort cases. By contrast, in no other Western country is there a civil jury other than some insignificant exceptions. To take a concrete example, duty, which we've heard a lot about over the last day and a half. Actually, no duty is frequently invoked by judges when they think that liability in that case should not be imposed, and they're unwilling to take a chance that the jury will get it right. By contrast, in continental legal systems, without a jury, there's virtually no invocation of duty, as there's no need to control the jury in a way that I just described. Similarly, in the area of products liability, we began with strict products liability and a consumer expectation test. That has largely gone by the boards because of discomfort about its providing virtually no constraints on the jury when the question is, how safe should a product be made? We've reverted to a risk-benefit test for most of those determinations. And yet, the Europeans have for 30 years employed a consumer expectations test without any notable difficulty. It is judges in Europe that are deciding these cases. So that's the background against which I've formed the views that I expressed today about Cardozo and the jury. And I'm happy to report that in all of the books about Cardozo, I found only one in which there was any coverage of the topic of Cardozo and the jury. Most books about Cardozo didn't even have an entry in their index for the jury. To me, that's a little short of astonishing. The civil jury has long been a controversial institution, probably the most controversial aspect of procedure that exists. In the 19th century, Mark Twain was criticizing it, and more recent commentators about the jury point out that for everybody who is an advocate of the jury, there's somebody who is a critic of the jury. The one text in which I did find discussion of Cardozo and his relationship to the jury didn't dissuade me from this topic because I don't agree with that author's assessment. With much trepidation, I don't agree with that author's assessment because that author is Andy Kaufman. To lay out my thesis, I find that Cardozo had little respect for the jury. It's interesting, Mark Graber in the last session was talking about Cardozo deferring. My thesis is that Cardozo did no deferring to the jury. If the jury's decision happened to coincide with his view, he was happy to affirm the jury verdict. But if it didn't matter. Andy, by contrast, concludes that Cardozo was assiduous in protecting the role of the jury, although he adds that Cardozo did not hesitate to take an issue from the jury when his reading of a record convinced him that the factual issue should be decided only one way. I'm not sure, Andy, how to reconcile those two statements, but I think it is the second part that he was perfectly willing to read the record and act as a super juror. In essence, this is my judgment about the way the facts should be determined. Yesterday, Richard Weisberg was asked about reconciling the Palsgraf case with the Hines case. This is the case in which we had a 16-year-old who was out on a diving board in a conflict between trespass and negligence. And his answer was, Cardozo was convinced that Hines should win and Palsgraf should lose. Yes, that gets it exactly right, I think. But what happened in those cases in the trial court? What did the jury do or not do, because the case was taken away from the jury in the trial court? And you know what? Read Hines, read Palsgraf, and you won't find out. Because that wonderful narrative of the facts that Cardozo provides says nothing about what happened in the court below until the very end where the decision of the appellate division is reversed or affirmed. So the best evidence bearing on my thesis would be an empirical inquiry into the way in which Judge Cardozo treated jury findings in cases that came before the court, best from his reports to his colleagues that Andy mined so well in his biography, which would show Cardozo's own views. I don't have that evidence. So I'm going to rely on the rigorous empirical method of my generation, a few illustrative cases. The four cases span his 24 years as a judge. One was early, two were in the middle, and one toward the end after Judge Cardozo became Justice Cardozo on the Supreme Court. I want to begin with an obscure torts opinion of Cardozo's, decided 2 years after he joined the Court of Appeals, cases Perry against Rochester Lime Company. And his opinion starts with a couple of paragraphs, a paragraph of facts about the case. The defendant stored dynamite on the banks of the Erie Canal. It did so in an unlocked box in a public place in violation of an ordinance. Two boys found the dynamite. They stole a container of it, took it home, played with it. The next day, they picked it up and took it off, and they had an 8-year-old trailing behind them who was intrigued by this. Well, you all know this wouldn't have been a tort case if the explosive hadn't gone off. Huge blast. The two teenagers are killed, as is the 8-year-old. Lawsuit just on behalf of the 8-year-old. After acknowledging that the defendant was negligent in violating an ordinance, the issue of proximate cause is identified. And Cardozo explains in the meat of his opinion why the harm was not reasonably foreseeable, emphasizing the wrongdoing of the two boys. He says, the decedent's death was not the proximate cause of the open chest in the highway, falling into a common trap of ignoring that the law doesn't demand that there be a single proximate cause be identified, and that there can be multiple such causes. My main point, though, is that nowhere does Judge Cardozo tell us the procedural posture of the case. What happened below is critical to the appropriate scope of what the Court of Appeals should be doing in that case, and the opinion is entirely silent about that matter. It's as if Judge Cardozo is deciding this case as both trier of fact and trier of the law in the first instance. That of course, was not the case. The trial judge had non-suited the plaintiff, and the appellate division affirmed. So the proper issue is whether a jury, whether on the facts of that case, a jury could reasonably have found that the negligence of the railroad was a proximate cause of the harm. Reasonable judges might disagree on that matter, but Cardozo ignores any consideration of that issue by ignoring the procedural posture of the case. I want to talk about Paul's graph, but I'm going to exercise heroic self-restraint and not talk about or criticize the substance of the opinion. In my view, that's already been done by Gary Schwartz, and I will leave that aside. We have somebody who is going to talk about the Paul's graph case. But I do want to talk about it in the context of the role of the jury in Cardozo's jurisprudence. And I want to start out with the facts, not even all the facts. I just want to start out with how far away was Mrs. Palsgraf on the Long Island Railroad platform when we had the push and the pull of the railroad employees with the passengers. Numerous commentators have addressed the matter of the distance. Judge Posner complains that Cardozo's facts were slanted and that he made up facts. Andy Kaufman concludes that Cardozo's characterization of Mrs. Palsgraf's location did have a basis in the record. Yet other testimony in the case would have supported a conclusion that she was much closer to where the fireworks were than the opinion says. I don't really care about the actual distance. I'm not getting into the substance of Paul's graph. What's important is that Cardozo states the facts in the same fashion as he did in Perry, as if he's the fact finder in the case, rather than to acknowledge that on the mixed evidence in the case, it was the jury's job to decide that distance. Moreover, given the verdict for the plaintiff that the jury provided, Judge Cardozo's role was to defer to what the jury might have found in that case. I'm going to skip the fact that Judge Cardozo situates foreseeability in duty, a matter that results in the court deciding foreseeability, a matter that is always dependent upon the specific facts of the case and the consequences of that decision, which my colleague Jonathan Carty has written about, and the number of courts that have arrogated that to decide duty on the specific facts of a case. I could go on with other cases, but the press of time keeps me from doing that. Professor Seavey, after reading all of Cardozo's torts opinions, reports that in a majority of them, the court ruled for the defendant. And of those, most came to the court with the plaintiff having prevailed below. So give me one more example that I'd like to talk about, and then I want to get to the Goodman and Pecora famous complement of cases. Nobody's mentioned the Flopper case, although those of us who teach torts love the Murphy case. The Flopper was an amusement ride in which a young man on a date with a woman who later became his wife fell and suffered a fractured kneecap. And no doubt considerable bruising of his pride, but so far pride is not a legally cognizable harm that one can sue for. He sued for the fractured kneecap. The ride consisted, it was on Coney Island, and it consisted of an inclined, smartly moving belt that made it difficult to remain on one's feet. Judge Cardozo adopts a robust assumption of risk doctrine to conclude that the plaintiff can't prevail. But the plaintiff had one hope, despite assumption of risk. After all, you saw this, right? There's nothing hidden here. He testified that when he got on the flopper, there was a sudden jerk. He was not referring to Steve Martin in doing it. Cardozo responds. He rejects the plaintiff's claim that the belt suddenly jerked. I'm going to read to you what he said. One who steps upon a moving belt and finds his heels above his head is in no position to discriminate with nicety between the successive stages of the shock, between the jerk, which is a cause, and the jerk accompanying the fall as an instantaneous effect. There is evidence for the defendant that power was transmitted smoothly and could not be transmitted otherwise. If the movement was spasmodic, it was an unexplained and it seems an inexplicable departure from the normal workings of the mechanism. An aberration so extraordinary, if it is to lay the basis for a verdict, should rest on something more than a mere descriptive epithet, a summary of the sensations of a tense and crowded moment. If there had only been the plaintiff's evidence, testimony on this, this makes a great deal of sense. But there was corroborating evidence in support of the plaintiff's jerk claim. When the plaintiff was thrown to the belt, his wife in front and friends behind him were thrown at the same time. Two other witnesses, the plaintiff's fiancée and her sister, testified that the belt suddenly jerked. So the issue emerges of whether the plaintiff's jerk testimony should be believed when coupled with the evidence supporting it. The defendant's evidence that a jerk was not possible was persuasive. The flopper was driven by a belt that transmitted power smoothly. But this dispute is quintessentially a jury matter, yet one where Cardozo arrogated that determination to the court without a word about the procedural posture of the case. Okay. I would expect skeptics here familiar with the twin Goodman and Pecora case that have been mentioned several times during the conference to say, well, wait a second, Mike, what about what Cardozo did in Pecora? Recall that in Goodman, Judge Holmes, following up on a suggestion he made in the common law, said, you know, for a while we'll let the jury decide what is negligence and determine reasonable care under that broad standard. But then when we get some experience, we'll develop rules. And that's exactly what he did in Goodman. He came up with this rule. When you're crossing an obscured railroad track, you got to get out. You have to approach the tracks, maybe do a pirouette, then get back in your car and drive across, or you are contributory negligent as a matter of law. So we had a very specific rule that Holmes developed. And 7 years later, after Cardozo replaced Holmes, the court in Goodman eviscerated what had been done with regard to that rule. Know what that does. The effect of that is to give back to the jury the determination of what is reasonable care. This is jury empowering what Judge Cardozo did in Pecora. Well, I think while what Justice Cardozo did in Pecora is jury affirming, I don't think this is about protecting the role of the jury. Rather, that is a mere consequence of Pecora. And in this, I find comfort because John Goldberg has reached largely the same conclusion in an article a long time ago. Nowhere in Pecora do we find that Cardozo believes that the jury is the appropriate decision maker. Thus, I would posit that Pecora is a product of Cardozo's pragmatism in judging. This was a perfect instance for him, where there was a rule that was completely out of tune with contemporary practice, for him to say, this is not how people cross railroad crossings. This was a bad rule, and took that out. Yes, it did affirm the jury's role, but that was not his purpose. Let me conclude with Cardozo's own words. What did Cardozo say about his views on the role of the jury in tort cases or contract cases or any other non-equity cases? What did he have to say about this? And we have a lot of writing by Cardozo. We have those series of lectures. We have the series of lectures and the books in which he's struggling with the issues of the day of deciding cases and how judges do it. Throughout all of his cogitations, Cardozo uses the word jury twice. Once as a throwaway, talking about a jury instruction, and once in referring to Professor Henry Edgerton's views on proximate cause. And he says he expresses approval of Edgerton's views, but then says, I do not say that I would follow him in all his conclusions as to the relative function of judge and jury. Okay? And we find out nothing more from Judge Cardozo about his views of the jury. Thank you.
Professor Green, thank you so much. Very interesting. And who knew you'd use the word jerk so often in a talk about Cardozo? Our final speaker of the panel this morning is Professor William Nelson, who is the Weinfield Professor of Law at New York University School of Law. I see that you just gained a new colleague on the faculty from the United States Attorney's Office. So congratulations to you and your colleagues, Professor.
Okay, I begin with a long paragraph about death and injury in the early 20th century. In the interest of time, I'll skip over it. Because of the frequency of workplace accidents and injuries involving public transportation, conflict between investors and entrepreneurs on the one hand and laborers and other ordinary people on the other was endemic to the law of torts in the early 20th century. During this period, a core principle underlying classical tort doctrine in New York was that a person could not recover for an inevitable accident. There were plenty of misfortunes to which people were subjected where they must suffer without recompense. And courts could not permit sympathy, although one of the noblest sentiments of our nature, to decide questions of law and thereby become a basis for transferring the property of one party to another. In short, classical tort doctrine demanded that compensation be paid to people whose injuries were caused proximately by another's wrongdoing, but not for injuries, however serious, resulting from innocent or remote conduct. Two early cases are illustrative. Laidlaw against Sage is one of them. It's from the 1890s. A burglar enters the business premises of the defendant, Russell Sage, and demands $1,200,000, a lot of money in the 1890s, and threatens to set off a bomb if he did not receive it. After he had discussed the matter with the burglar, Sage positioned an employee, Laidlaw, between himself and the burglar and then refused the demand. The burglar then set off the bomb, and Laidlaw is seriously injured, but Sage is saved. Laidlaw recovers a jury verdict against Sage, but the Court of Appeals reversed, holding that the bomber had caused Laidlaw's injury and that there was no evidence in the case of any necessary relation of cause and effect between Sage's words and actions and the explosion which caused Laidlaw's injury. Partington against Abraham of Abraham and Strauss was analogous. The department store maintained a swinging door, which another customer pushed open, whereupon the door ricocheted back and struck and injured Mrs. Partington. In reversing a jury verdict for Partington, the court found that the doors were no less safe than similar doors used in like establishments, and that carelessness in any form of door may inflict injury upon one who happens to be sufficiently near it. The court continued, no doubt the plaintiff has been the victim of a lamentable accident, but it is attributable, it seems to me, not to any fault of the defendants, but rather to the hasty carelessness of a third person over whose movements and conduct the defendants had no control. By the opening days of the 20th century, however, these classical tort doctrines could no longer claim to be the only approach to issues of causation. A competing popular conception of liability was emerging. I'll just give one of my quotes from a lawyer who said, "Juries are naturally sympathetic and inclined to take the view that an employee should be compensated when injured, no matter what the judge tells them about the law." These newly emerging, though not uniformly accepted ideas of causation and tort liability were even beginning to gain legitimacy in judicial circles. As a result, classical tort doctrine no longer provided easy answers in every case, and judges began to recognize that issues of liability and causation involved policy choice. Competition between the new and old paradigms left no doubt that determining whether a plaintiff had a legal right or when a defendant had committed a wrongful act required courts to consider whether there was a relationship between the parties of such a character that as a matter of good faith and general social policy, the defendant had a duty not to harm the plaintiff. So there's this tension between two different views of what tort law ought to be about. And the Court of Appeals sought to work out the tension between these competing paradigms of liability in Paul's graph. Again, I'm going to skip over part of it since we're running late and go down to Andrew's opinion in dissent. We all know the facts. So the classical understanding of negligence and proximate cause was elaborated by Judge Andrews in a dissent that would have affirmed the opinion of the appellate division directing judgment for the plaintiff. In Andrews' view, everyone owed to the world at large the duty of refraining from those acts that may unreasonably threaten the safety of others. Negligence consisted in breach of this duty, and the railroad had been negligent in Paul's graph when its employees permitted a man to board a moving train and even assisted him in doing so. But obviously, as Judge Andrews himself had observed in another case, negligence liability had to have its limits. The limit was the doctrine of proximate cause. By virtue of this doctrine, negligence did not invariably give rise to a cause of action for damages unless the damages were so connected with the negligence that the latter may be said to be the proximate cause of the former. By proximate, Andrews meant that because of convenience, of public policy, of a rough sense of justice, the law arbitrarily declines to trace a series of events beyond a certain point. not as a matter of logic, but of practical politics. In determining proximate cause, it was necessary to ask questions such as whether there was a natural and continuous sequence between cause and effect, whether the one was a substantial factor in producing the other, and whether there was a direct connection between them without too many intervening causes. For Andrews, inquiries into proximate cause always involve questions of fair judgment and could lead at best not to a clear rule, but only to an uncertain and wavering line that would yield practical results in keeping with the general understanding of mankind. Andrews' language about public policy, a rough sense of justice, and practical politics has a modern 21st century sound, but it was actually backward rather than forward looking. Its close relative was the Supreme Court's opinion in Lochner against New York, where the court created an implied due process right to achieve its practical policy goal of protecting employers from wage and hours regulation. Lawmaking designed to achieve policy goals was not something with which judges were unfamiliar in the early 20th century. Indeed, in the context of tort liability, New York judges had long been engaged in policy-making cases like Laidlaw against Sage and Partington against Abraham that I discussed earlier. A third case, a 1921 decision from the Second Circuit, also supported Andrews' policy views. These cases are remarkable and almost unbelievable. The plaintiff was the widow of a deceased alien who had been arrested and imprisoned on the orders of Attorney General A. Mitchell Palmer. There's probably one of these cases going on right now. She alleged that her husband had been subjected to physical and mental torture by his federal captors until he committed suicide as the only means of escape. Nonetheless, 2 out of the 3 judges sitting on the Second Circuit panel voted to dismiss her complaint, declaring that it would be a most unreasonable inference to say that suicidal mania can be regarded as a natural and probable consequence of either mental or physical torture. The dissenter, in contrast, thought it obvious that the infliction of such wrongs continuously over a long period of time might naturally and probably would lead to self-destruction. However, as the dissenting judge further observed, the concept of natural and probable consequence, proximate cause, over which the court was battling was merely an expression to explain the reason for the decision on the fact. Of course, authority also existed for the reform principle favored by Cardozo and the Palsgraf majority. The case I particularly talk about here is Glanzer against Shepard. We've already heard about it, where Cardozo says the weigher could foresee harm to the buyer as well as the seller, and therefore the weigher was liable. So writing for the Palsgraf majority, Chief Judge Cardozo expanded on his holding in Glanzer and further embraced the reform position as the underlying principle for the law of torts, proclaiming that a finding of negligence would entail liability for any and all consequences, however novel or extraordinary. The Chief Judge held that the doctrine of proximate cause would not limit liability as Andrews' dissent suggested it had traditionally done in New York law. In Cardozo's words, the law of causation, remote or proximate, is thus foreign to the case before us. When this holding was added to the ruling in Glanzer that liability depended on the mental state of actors rather than the consequence of their action, the reform principle was complete. Cardozo and a majority of the Court of Appeals had rendered people in possession of power responsible in damages if they foresaw harm resulting from their actions, however remote the harm might be, and by whatever indirection it might be produced. Liability depended entirely and only on foreseeability. But at the same time, Cardozo and his brethren brought the reform program to fruition, they also imposed limits on it. Cardozo and his colleagues were no radicals. They appreciated the uncertainty that entrepreneurs, who could always foresee harm, would face if they were liable in damages whenever harm, however remote and indirect, occurred. Proof of negligence in the air, Cardozo thus wrote, would not do. Defendants who were negligent would not be liable for all harms in the world, but only for damages suffered by those at whom their negligence was directed. Negligence, Cardozo continued, was not an open-ended concept, but a term of relation, pursuant to which the plaintiff sued in her own right for a wrong personal to her, not as the vicarious beneficiary of a breach of duty to another. Cardozo concluded that no negligence had occurred toward the plaintiff in Palsgraf, and hence that she could not recover damages because to the eye of ordinary vigilance, the act of helping a passenger onto a moving train was innocent and harmless with reference to her. I want to now just spend 5 minutes tying this Palsgraf case in to what I think we've been talking about through much of the conference. Palsgraf was a brilliant opinion by a great judge. I want to conclude by asking what made the opinion so brilliant and the judge so great. Was Cardozo great because he was politically savvy, or was his opinion in Palsgraf brilliant because it was a legal decision that removed New York courts from the politics of personal injury law? Does it make sense to talk about law and politics and try to distinguish between them, as I am suggesting here? I really need and want your help. Let me begin by breaking down my general question into smaller parts. First, did the recognition by both Cardozo and Andrews that tort liability needed to have limits constitute a political or a legal judgment? Suppose that a Chevrolet passes a red light and collides at the intersection with a Toyota passing through the intersection on a green light. Both General Motors and Toyota caused the accident by manufacturing the vehicles without which the accident could not have occurred. Should GM and Toyota be liable? Is the decision under the doctrine of proximate cause to impose liability only on the driver of the Chevrolet who ran the red light a political or a legal judgment? Does the law's pre-commitment to fault liability render the decision a legal one? What if the driver of the Toyota could have avoided the accident if his vehicle had been equipped with some anti-collision device that Toyota had decided was too costly to install? Does sorting out liability then become a political rather than a legal judgment? Is the judgment legal if the community at large agrees with it? Is it political if the community is divided? In Palsgraf, Cardozo made a decision to let juries, which often sympathize with plaintiffs. Clearly you're in disagreement here. I'm with Andy. To let juries, which often sympathize with plaintiffs rather than judges who often sympathize with defendants, resolve the issue of proximate cause. Was that a political decision? Was it political because it increased the likelihood that plaintiffs would win cases? Or was it legal because it deprived judges of the capacity to make the practical policy choices, political choices, that Andrews understood judges needed to make? Decisions that would often help defendants, and because it put the entire decision-making process into the hands of jurors as representatives of a consensus community. Perhaps asking whether something is legal or political is to ask a wrong question. Perhaps there's no useful dividing line between law and politics, but the public keeps drawing the line. As we have been meeting in conference here, the Senate Judiciary Committee has been holding hearings on the nomination of Neil Gorsuch to the Supreme Court. I think it is fair to say that President Trump nominated Gorsuch because he expects Gorsuch to advance Trump's political agenda of overruling Roe v. Wade upholding Citizens United, etc. Democrats are concerned that Gorsuch will indeed be such a political judge. How can Gorsuch respond to these concerns, however, other than by saying, which he said Monday and Tuesday over and over again, that a justice's job is a legal, not a political one, that he will distinguish politics from law, that if he thought law was just politics while wearing a robe, he'd take the robe off and leave the bench, and that he will always make decisions on the basis of law. I'm confused and need help. One thing I'm not confused about is Benjamin Cardozo's greatness, and perhaps his brilliant opinion in Paul's graph can help us better understand what made him great. And you didn't have to show me your sheets.
I didn't even get to use my sheets of paper. We have a couple minutes. I wonder if Professor Kaufman wants to say a few words
He
at the
does.
beginning. Apparently so.
I just wanted to say that I think Mike Green has got his hands on a really good topic. And I think that once you read the Cardozo memoranda that are in the New York State Archives, he's asking a somewhat different question than what he's asking now. Because I think what you'll find is, I think somewhere between 25 and 30 cases in which Cardozo used a record assiduously to reinstate a jury verdict that has been taken away by the appellate division, or that says that the jury should have left free in the first place to decide the case. And he's quite explicit about not liking to do this, but he thinks it's his job to read the record carefully. And I think the question you're going to end up asking is, why does he do it in some cases and not in others? And it's going to take him into Bill Nelson's question of, is Cardozo asking himself a question about is this law or is this politics? Or is this Cardozo, the former practicing lawyer, saying, you know, I think I can tell when I should be one and not the other based on my experience and he didn't say based on my own sense of self, but I think it may be an example of his own sense of self and his own ability to make it.
Thank you. Other questions? Yes, sir.
It's interesting to see why of your relations and mention of foreign policy. And you said it's politics. You're not saying it's Democrats versus liberals. It's a question of policy. The politics in the original term.
I think he is doing exactly what you say he wasn't doing. So buried in what I said are several historical judgments and assumptions. So the first one is that in some sort of sense, legal realism is nothing new in the 1920s. Judges had been making policy judgments, practical political judgments, for at least a century in America, probably for 2 or 3 centuries in the common law more generally. So that the idea that judges had to make policy judgments is not something that Carl Llewellyn invented, or Cardozo for that matter. And I think, as I read the 19th century New York cases, as I read the New York cases up into the early 1920s, the cases decided by upstate Republicans, uh, I see very much not practical politics, but defense of property rights and traditional Protestant, traditional New York Protestant elites. Uh, and suspicion of immigrants, uh, suspicion of working class demands, uh, and that's why I see Andrews very much as one of those traditional Republicans, more moderate than some, but still one of those traditional Republicans. And that's why I associate him with Peckham's opinion in Lochner. Uh, so I'm, very self-consciously saying that Andrews is doing exactly what you say he isn't doing. He is defending the ability of judges to intervene and say, okay, jury, yes, you were right, there's cause and fact, but as a matter of politics, I'm going to hold this defendant not liable because as a matter of political morality, I don't think this defendant ought to be liable. And that's a judgment which it is appropriate for me as a judge on the bench to make when reviewing the jury verdict. Oh, look, this is like a John Marshall opinion in Marbury against Madison, where both of them are deciding for the wrong side, but I think both of them are very clear, Andrews and Cardozo, about what side they're on as a general matter. In this particular case, and they want to show, both of them, they're good judges, they want to show we're impartial, that our legal principle can lead to results in favor of both sides. But I don't think it's, I'm with, I'm with Mark, I think it was on the last panel, and saying that, no, I guess it's with, is it with you, John, that's saying that the language matters. It's Ben, okay, I'm sorry, Ben. Yeah. The language matters, not the result. I see Cardozo as saying we can give the whole question of liability to the jury if we only instruct them right and say, if you find that the defendant could have foreseen harm to the class of which the plaintiff is a member, you can find negligence. And then there's nothing left for the judge to intervene in. So that's my reading of Paul's graph. Now Goldberg's going to attack me.
Yes.
I'm not going to ask a question of Michael that relates to your reading as well. So, Mike, I thought it's a really interesting set of observations. I agree with Andy's discussion. It's stunning that Cardozo has so little to say about this issue. Right? A couple of things. Some of the cases you talk about, obviously, whether or not he has anything to say about the jury will depend, of course, on the procedural posture of the case. And I think Hines was on a motion to dismiss, so there would have been no occasion to talk about the jury because there was no jury. The trial court just threw it out because they said he was trespassed. I wonder, I don't know, I'm completely ignorant whether back then there were what the rules were and the standards were for ordering these trials, and so that's something that you might want to look into when you really have. On Paul's graph, finally, and then I'll shut up. So I don't know that Paul's graph is your best candidate for being kind of insensitive to or indifferent to juries. So I would say Cardozo may have read the jury verdict generously to the jury. He just thought that even having done so, he'd still lose because even at a closer distance, the conduct of the conductors was, as Bill described, not careless as to her. So here's some of the language. The range of reasonable apprehension is at times a question for the court, and at times, if varying inferences are possible, a question for the jury. Now, here's an interesting clause. Here, by concession, there was nothing in the situation to suggest to the most cautious mind that the parcel wrapped in newspaper would spread wreckage through the station. Now, I don't know where, I actually don't know what the reference is, the by concession reference is in that sentence. It might be worth looking into the record, or maybe somebody figures this out. Who conceded what? Was that by concession of the parties, the lawyers, is it in the brief? I take his point to be, look, I don't care if she was 25 feet away, or 30 feet away, or 35 feet away, or whatever. If a guy's carrying a bundle of papers that don't say TNT on them, and you push him, the idea that someone standing 20 feet away is going to get hurt is preposterous. Nobody would expect that. Nobody would say, don't push that guy because you're going to hurt that lady over there. And that's not susceptible to reasonable disagreement. And therefore, in this case, it was okay for him to say, as a matter of law, there was no carelessness as to Mrs. Palsgraf, and therefore no breach of the duty owed to her, and therefore to the.
Would you please join me in thanking our panelists today, Professor Green, Professor Lee, Professor Nelson. Sam, do you have an announcement?
Thank you, Larry, and thank you to the panelists. Another terrific panel, great way to end the morning proceedings. Now we'll make our way right on the other side of this partition for lunch and regroup here.
Thank you very much. Thank you. Just really terrific. John, thank you very much.
Thank you very much. Appreciate it. Great to see you.
That was just great. That was terrific, three terrific talks.
Fascinating talk, really. Right, exactly. Yeah, it's hard. Yeah.
Thank you.
No, I mean, the Trill is excellent. I really, I saw that case and said that somebody's got to talk about it.
Actually drove here because
In their instructions, comment.
I brought her, but I dropped her off.
Did Cardozo get?
But
He had these, but it might be interesting.
and then my parents are in Jersey, so we're gonna go see them.
I don't
You're from Teaneck?
I don't know what the new rule is. But that's certainly an area of.
Yeah, that would seem to be very.
Yeah.
Yes, exactly.
You know, it's
That's right next to Hackensack. Yes, I went to Riverdale. I said more. Oh, Nick's. Yeah. Where Huffman News used to be. Now it's.
I was also wondering whether transcripts automatically order at that time.
from what Andy has said.
Yeah, the train station.
There's a talk about him scouring.
Right.
You mean the about stupid house? Yeah.
Parties submit, right,
Submit
right.
as part of the.
Oh, I have not.
But usually also then transfer.
Yeah,
Right,
it's a thumb.
exactly.
Right, there's a thumb.
I just didn't know, I don't know what it. Eventually it became part of it. You can't appeal it.
Well, it's dangerous. I always find that. More things I need to do.
Right,
Yep.
that's right.
The beauty.
Right.
Exactly.
In Milford, yeah. No, okay, that. Wow, that's. So yeah, it's I don't get up here that often. Right? So, yes, you're facilitating that. Oh, really? Today? Yeah. Well, who knows what the traffic's going to be, but in any case, Sunday. Sunday's all right. Yeah, it should be all right. No big events that I know of. All right. And keep stuttering until this case is over. Right? I think you saw that.
Hi, good to see you. How are you?
Why does he do these? That's a whole other problem. Are you going? Yeah, they're all, it's all me. All the images. Oh, yeah, I'm gonna, yeah, where would you start? How would you do it? Right, what planet are you on? I mean, the one thing I have to do is just lift it out of the water. So I mean, they sort of make it like a new thing. There used to be, they didn't dream, but now they're doing it every kind of like. So it's other.
Oh, I know.
Which ended, um, always, after 25 years, you were out. Liability is your ordination after the irony of this, I never, and I think that's what religious fanaticism, is humanizing. So it's really, and for a while, it remained that but I think the last time the marriage right now, so that one wasn't.
Okay, well, welcome back, everybody, from that terrific set of morning panels and from lunch. And in introducing our final panel of the conference, I just want to say a couple more words. First of all, a couple more expressions of thank you. It's my opportunity to thank Howard Glickstein for joining us. Larry introduced Howard. Many of you know Howard from over the years, and for all of his dedication to Turo. Before my time at Turo, but I was well aware and well acquainted with Howard well before I joined the Turo faculty. And I appreciate Howard's support for the conferences that I've put together over the years and your participation and attendance at the conferences. In addition to the rest of the Turo faculty who have been joining us, and the administration and the students, and for those who have not yet had the chance to meet Shira Bloom, some of you weren't here yesterday, Shira is standing in the back, our articles editor. You've been in touch with her by email, and we'd really be interested in having you contribute to the law review issue. You can look in your, I don't know if it'll be in your mailbox, but you can look online within the next few weeks. We hope to have the Brandeis law review issue out from last year's conference. It can give you an idea to achieve in next year's issue based on this year's conference. A number of you participate in the Brandeis conference, or to reassure you that it is going to be published, and you'll be seeing that issue very soon. And we look forward to working on the Cardozo issue as well. If you have any questions, feel free to speak with Shira. Many of you worked with Sabo last year. She's here as well, and you can speak with me as well about the law review issue. I also want to thank, I appreciate all of your words of thanks over the couple of days, and I want to take this last opportunity to thank you all once again, because people have asked me, how am I doing? How do I like things? And I said, this is great. I'm done when the conference starts. Now I get to sit back and enjoy the presentations, and it's you who make the conference what it is. So thank you all for joining us. I really appreciate it. I also, in introducing the final panel for the conference, I want to mention, putting a two-day conference together, you have to make sure the last panel is worth everyone's while in staying. And I appreciate you all staying, and this is the reason why. So I'm looking forward to this panel. And a final word of thanks to the panel moderator. And in conjunction with thanking Lou Kornreich, I want to thank Judge Lopez once again, and publicly mention that over the course of the last year, the Judicial Institute has established our initial advisory board of lawyers and judges from across the country, and we're so happy that Judge Lopez and Judge Kornreich have both joined the board and participated in our program. So I just want to thank you again for being here, and with that, I'll turn things over to Judge Kornreich.
Thank you very much, Sam. Thank you, Dean Balin. I am an alien. I'm the only non-scholar in the room, and I include Judge Lopez on the other side of the fence because of his scholarship. As an alien, I'd like to offer a few comments. First, I want to applaud you on your scholarship, but most of all on your collegiality. There's a lesson that the bar can learn not just from your content, but from the way that you treat one another. It's been a joy for me to witness the polite exchange among all of you, and I've learned quite a bit. And I hope that the film and the audio, and eventually the law review when it's published, will be listened to, watched, and read by the bar and the bench. There's so much here that's worthy. One of the comments I want to make is that there is a separation now between the academy and the bar and the bench. And I'm hopeful that conferences like this can bridge that divide. Lawyers should hear it, judges should hear it, and I've heard it, and I think it's been wonderful. Another comment that I'd like to make is with respect to the Jewishness or Judaism of Judge Cardozo. And remember, I'm an alien. I'm not a scholar. I am not offering any scholastic comment. But much has been said about Judge and Justice Cardozo's association with Jewish institutions, with his community, the Sephardic community in New York City. And some has been said about his cultural identification and his spirituality. I'd like to say just briefly that there may be more of a substantive nature that may be worthy of inquiry. We heard this morning about the importance of language. There's a statement in the Bible, in the Torah, tzedek, tzedek tirdof, justice, justice you shall do. And this is commonly understood as the Jewish gift of social justice, the emphasis on social justice. That's a good definition, but there's more to it. If you look at the substance of Jewish law, the repetition of justice, justice relates to law and equity. There's another doctrine, lo v'shamayim hi, which means there's nothing left in heaven, which I would submit is a precursor to the ideas of context and pragmatism. By nothing left in heaven, we mean don't look for some spiritual guidance. Judges have to have their feet on the ground. They have to understand that the generation that they exist in has something to do with the outcome of the case. I just give you these ideas to show that there may be something more to Cardozo's Jewishness than cultural affiliation. I don't know the extent to which he was trained in any of these concepts as a younger man. We do know from Professor Kaufman's excellent biography that he distanced himself from substantive Judaism at a very early age, although he never distanced himself from cultural affiliations. Thank you for listening. And with that, we are going to begin with our first lecture from Professor Richard Friedman. He is the Aline and Alan F. Smith Professor of Law at the University of Michigan. He'll be speaking on Cardozo on the Supreme Court.
Thank you, Judge. And I do want to add my thanks to those that everybody else has offered. This is a terrific conference. I'm delighted and honored to be a part. I really regret having had to miss yesterday because of teaching and other obligations at school. And one pleasure, by the way, has been just the chance to and the incentive to go back to Andy's biography, and I've just enjoyed it very much on that second look. So, when President Trump announced his nomination of Neil Gorsuch, the sixth most senior judge on a federal appellate court in the hinterland, he did it in a formal, nationally televised ceremony. Judge Gorsuch, you might have noticed, squeezed the shoulder of his wife during the announcement. It was a gesture that I took to signal not only his thrill at the nomination, but his joy at being able to share it with her. Now compare the nomination of Benjamin Cardozo in 1932. Cardozo was the chief judge of the highest court in the largest and most important state in the nation, the most revered and probably the best known judge in the nation, not on the Supreme Court. And as John pointed out this morning, I mean, that made that was much more significant back then than it would seem now. When Justice Holmes retired, and interest immediately centered on Cardozo, he insisted privately that he wished not to be asked, and that he didn't believe he ought to accept the nomination if it was offered. But in fact, and it's always I'm relying on Andy here, he resolved that if asked, he would accept. As he put it a few months later, he accepted it as one must accept sickness or death. And So when the offer came by telephone, he accepted immediately, and the White House announced it without fanfare or elaboration, just that the president had sent Cardozo's name to the Senate. It was received with universal acclaim. There's a quick hearing, as was the practice. In those days, the nominee did not testify. There's a unanimous confirmation without a roll call vote. We'll see when that happens. So anytime in the near future. The appointment doubtless appealed to Cardozo's vanity, but his pleasure was considerably muted because the woman who was his life partner, really his sister Nellie, had died a little more than 2 years earlier. Cardozo described the loss as irreparable and said, I have to ask myself with wonderment why I should value praise now that the one who would have shared it with me so fully has gone from me forever. So, and indeed, it appears that Cardozo was suffering from a mild form of depression during his tenure on the Supreme Court. He sometimes expressed a wish that he were dead. He was also in vulnerable physical condition with a heart that was already significantly weakened by the time he took his seat. He was in a strange city, far removed from his friends in New York and Albany, and dealing for the most part with an entirely new body of law, one that he enjoyed much less than the docket of his old court. And for all but the last few months of his active tenure, he was the junior justice on the court. And that mattered in large part because he was unlikely to get too many choice assignments. Here's a story I got from Joe Rao, who was his last clerk, that Felix Frankfurter asked Rao at one point, Joe, when will that swine use? And Rao was very particular that he remembered the word swine. Stop giving Cardozo all the bad opinions. So, Andy interviewed C.C. Burlingame, was born in 1858. But he started early. Andy's older than I am, and he started earlier. So I just, I got to rely on people who were born after 1900. He was a junior justice. He didn't get too many choice assignments, and the court was run by a chief whose style and driving prompt decision-making was very different from the slower, more deliberative process that Cardozo favored and to which he'd become accustomed. Doesn't sound good, and yet for all that, I think Cardozo was probably the greatest short tenure on in the court's history. I say short tenure because his active time was just 5.5 years. Well, several factors. First, timing. He took a seat in March 1932 near the low moment of the Great Depression, less than a year before the beginning of the New Deal. And he became mortally ill in December in the crisis year of 1937. But the crisis had in effect passed. Earlier in the year, the court had issued an important transformational, I don't use the term revolutionary because I don't think it fits, but important transformational set of decisions that helped to set the framework of modern constitutional law. And even more recently, the Senate had defeated FDR's court-packing plan, and Roosevelt's appointment of Hugo Black to replace Willis Van Devanter consolidated the trend of decisions, ensured that the conservative bloc would not control the results anymore. So the main battle was in effect over. One would be hard pressed to pick another 5.5-year period in which a single justice could make so much of a difference. And next, I think Cardozo was on the right side of history. With respect to the issue that mattered most, with respect to the issue that was most salient, which was the use of governmental power, he was. I think it's clear that he was, but obviously opinions differ. But I think that it's a widely shared sense that the decisions that the transformational decisions were correct, and it's easy enough to say from the perspective of 80 years that, well, there are some areas in which the court fell short, but I think it would be hard to come up with many decisions, major or minor, in which any other member of the court appears from the perspective of the modern day to have taken a more appealing position than the ones that Cardozo did. So he was on the right side. At times he consoled himself, feeling that his limited power as a junior. He said, "Well, at least my votes matter," and they did. But he mattered for in many other ways and for other reasons. And one important factor there, I think, was a matter of personality. Cardozo had put it all together: guts, vanity, self-confidence. He was sure of himself in doing his job. And coming in as the junior justice, it didn't slow him down at all. One story, I got this from Charles Wyzanski, the old district judge who was a lawyer for the New Deal, and he had a case, Zimmern v. United States. Presumably you've never heard of it because there's no reason why you should have, but Wyzanski argued, and the case fell apart at the argument. And later, Wyzanski was having tea with Cardozo, and Cardozo said to him, young lawyer, "I never thought that case was worth an argument by you or an opinion by me." Graciously put, but it gives you. He didn't mind asserting his own self-worth. So it's notable in this context that his first opinion on the court, in a case argued just a week after he got on the court, was a dissent. And that is the first time ever since the court abandoned the practice of seriatim opinions when John Marshall took the court. It's the first time ever that a justice's first opinion was a dissent, and it's actually the first time since the period of John Marshall that a new justice's opinion was anything but an opinion for the court. So he wasn't afraid to speak out. In Panama Refining versus Ryan, a case on delegation, which I'll talk about a little bit more, he dissented alone. Which was unusual. And in the Schechter Poultry, he again wrote a dissent which Stone then joined. These were major cases. I'm sorry. In Schechter, it was a concurrence, which was a very unusual thing in that era to have separate concurrences. Usually, if the court usually there was an opinion for the court, there might be dissents, but concurrences were unusual. But Cardozo wanted to speak his mind. In other cases, he had a significant impact without published opinions, either by correspondence with the other justices or actually by writing opinions that he intended to put forward, and then the justice who had the majority opinion altered the opinion. So three notable cases: the Blaisdell case, the great case on the contracts clause. Cardozo wrote a concurrence which gave much more flesh to the argument than Hughes' original opinion had, and Hughes adopted much of the substance of it into his own, rendering Cardozo's opinion unnecessary. The Grosjean case, an important First Amendment case in which Cardozo's planned concurrence persuaded Justice Sutherland to alter fundamentally the whole nature of the opinion. Railroad Board versus Alton, Cardozo gave Hughes important substantive argument that he incorporated into his dissent. I think Cardozo is notably different, say, from the next most junior justice, Owen Roberts, who whom I've accused of a form of judicial timidity, and the great fulcrum moment when the minimum wage case came up in 1936, Moorhead v. Tapaldo. Roberts went along with the majority opinion, though with grave doubts, never spoke his mind as to why he was doing it in unusual circumstances, and it created, in the end, a very bad appearance when the next year he, in a different case in what he thought was a different setting, he went along with the new majority in West Coast Hotel. I don't think Cardozo would have done that. He wouldn't have silently gone along with an opinion that he didn't, that he wasn't comfortable, with. And then also, I think we have to think about Cardozo's conception of the nature of law and legal change, and the role of the judiciary. So. I think deference was a good deal of his approach, deference to the legislature, deference to administrators, his dissent in the notable case of Jones versus SEC is important in that. I'll note the discussion at the last panel about to what extent did he defer to the jury. Interesting, I think that if there was a differential in the extent to which he was willing to defer to coordinate branches and the extent to which he was willing to defer to the jury, I think it could be explained. Perhaps if there is that differential, I'm not sure. Perhaps a form of elitism, recognition of a coordinate branch. I think he regarded government as largely cooperative. His opinion in Social Security's cases, which were really the plum assignment he got on a salient issue, reflected that idea of federal-state cooperation. Important dissent he wrote in the Ashton case in bankruptcy. Similarly, his views on delegation, which were much more receptive than those of any other justice, reflected a sense of a cooperative form of government between legislature and executive. He was modest also in the sense of avoidance of issues. The type of technique we've come to think of associate with Justice Brandeis's concurrence in the Ashwander case. An example is the Carter-Cole case, which is one of the most important cases before the transformation in 1937. A 1936 case involving a major piece of New Deal legislation. It involved some labor provisions which were troublesome, and some marketing provisions which to Cardozo and the other liberals seemed clearly okay. And Cardozo, in a dissent, said the way to approach this case was with the marketing provisions, look at those first. Those were clearly valid. They were enough to justify the tax that was at issue. The labor provisions never should have been touched by the court. He says the complainants have been crying before they're really hurt. So it was, as one might expect, as I say, an avoidant case, an incrementalist approach. In many cases, his approach was one of, as one might expect, not doctrinaire in the sense that he didn't look for sharp categorizations, but relatively soft tests. So let's take Panama Refining and the Schechter case. Both of those presented questions of the proper scope of delegation. In Panama Refining, in which, as I said, he dissented alone, the rest of the court all said that the provision involved there was unconstitutional. What it did was it gave the president authority to prohibit the transportation of interstate commerce hot oil produced or withdrawn in violation of state law. And Hughes expressed the fear that if this were allowed, he said it would be idle to pretend that anything would be left of limitations upon the power of Congress to delegate its lawmaking function, which I think to Cardozo looked a little bit hysterical. Because he pointed out, wait a second, the president is authorized to do only one thing, which is if he deems it proper, prohibit the transportation of hot oil. And so he said discretion is not unconfined and vagrant. It's confined within banks that keep it from overflowing. And beyond that, he said, well, okay, you can look at the statute and saying it either leaves it up to the president's arbitrary will, or you could read it more generously that it incorporates standards from elsewhere in the statute as to what policy goals should guide the president. And so obviously you should do that, and you look to the whole structure of the act. You can find enough of a policy guide to make the delegation valid. I think to the modern day it looks much stronger. At least it did before January. I've had some doubts since looking at Section 212F of the Immigration Naturalization Act, which is a broad delegation. But I think Cardozo was right there. And then with Schechter, at that point, then in Schechter, which involved the whole code-making authority under the National Industrial Recovery Act, and the Blue Eagle, which gave the president enormously broad power to control industry. Cardozo went along with holding that it was an excessive delegation because he said, "Well, this is different. Here, discretion is unconfined and vagrant." And I think doctrine has gone beyond there, but I think if you look at that case, I think the court may have had a point that maybe that was excessive. Schechter also was one of the cases presenting the question of limits of the commerce power, and the court tended to speak in terms of direct, indirect. And to Cardozo, that was just too rigid, too categorical. In his to him, it was a matter of degree. And he put it nicely in a dissent in his dissent in the Carter case. A great principle of constitutional law is not susceptible of comprehensive statement in an adjective, which I think expresses a good deal of his approach. And that approach was borne out later in the Jones and Laughlin case, and then beyond. And after his death, the court actually adopted the argument from the Carter dissent. I don't think he's always right, by the way. I think that there are times where the court should be speaking in terms of principles and hard-edged doctrines, but. I think he was given that issue, the idea of trying to draw a line between direct and indirect effects on commerce didn't work, and he had a clear sense of that. Beyond all that, and this is reflected most in his opinion, the unpublished opinion, as I said, in the Blaisdell case, Cardozo understood and was able to articulate possibilities of growth and change in constitutional law without being faithless to original intent or text. And that's one of the great projects of constitutional law to be thinking about that. When I teach the course, I always enjoy teaching Blaisdell because although it doesn't fit within any doctrinal subject matter areas that we tend to focus on, the debate between Hughes and Sutherland in that case is really a wonderful pairing of different approaches to constitutional decision making. And in reading that Hughes' opinion, which is quite wonderful, I think you got a always bear in mind that it was Cardozo who had pushed him into the broad statement that he made. So I think in 5.5 years, it was quite a spectacular record of accomplishment for a junior justice. So thanks very much.
Next, we have Professor Robert Pushaw, the James Wilson. You're going to go next? Excuse me. All right, Professor Winter will go next.
Sorry.
Remember,
Introduce him if you want.
I'm an alien. Okay. Stephen Winter is the Walter S. Gibbs Professor of Constitutional Law at Wayne State University School of Law. He's going to be speaking on Cardozo's Freudian slips.
Thank you. And I also want to apologize for not being here yesterday. I have 4 hours of class on Thursday. They're great classes. They're a joy to teach, but they're impossible to reschedule. So I'm sorry I missed yesterday. Those of us who teach appellate opinions for a living are indebted to the great stylists, Marshall, Holmes, Cardozo, Jackson, whose prose rises above the mostly turgid judicial plane. Cardozo could write, but his was an alien grace. Cardozo, to invoke his own typology of judicial styles, was by turns magisterial, laconic, refined, precious, and persuasive. He could turn a phrase, but his prose was often overwrought. At his aphoristic best, he rivaled Holmes. At his worst, Cardozo could obscure thought, quote, behind a cloud of words. That's from Andrew's Dissent in Paul's. Judge Posner notes that there are two diametrically opposed views of Cardozo's style, some praising it as terse and lucid, and others criticizing it as fancy and overly precious. Posner splits the difference, as it were. Quote, the former style dominates in his judicial opinions, the latter is far more marked, though not dominant in his non-judicial writings. There is some truth to this assessment. Several of Cardozo's best-known opinions, in particular those in McPherson, Tauza versus Susquehanna Coal Company, Wood versus Lucy Lady Duff Gordon, and Hines versus New York Central, are models of clear, edifying writing. The famous How Trackless Was the Ocean passage, from the nature of the judicial process, in contrast, is characterized by extended and mixed metaphors, literary allusion, and ornate prose. Indeed, Posner has to edit the excess in this passage before he can pronounce it, quote, a gem. But there is ample evidence to the contrary of Posner's thesis. Some of Cardozo's best epigrams appear in his extrajudicial writings. Consider three of my favorites, and they span 3 different books, Paradoxes of Legal Science, Nature of Judicial Process, and Law and Literature. First, they do things better with logarithms, yet unwritten is my table of logarithms, the index of the power to which a precedent must be raised to produce the formula of justice. The second, life casts... Oh, sorry, did you hear that? Or should I reread that quote? The second, life casts the molds of conduct which will someday become fixed law. Law preserves the molds which have taken form and shape from life. And the last one, there is an accuracy that defeats itself by the overemphasis of details. There is a flow and grace to these lines that enhances rather than defeats their clarity. These observations are pithy, punchy, profound, and nearly as good as the classic line from People versus Dufour, bemoaning that, quote, the criminal is to go free because the constable has blundered. Conversely, Cardozo's judicial prose was often overworked. Consider his opinion in Welch versus Helvering. After Welch's family grain business had declared bankruptcy, he became a purchaser for another grain company. Over 5 successive years, he paid off the bankrupt company's debts and took the amounts as business deductions against his commissions. The percentage of deductions ranged from, I think, about a third of his commissions to a little bit over half, so they were pretty substantial. The commissioner recognized that these payments to former customers served bona fide business purpose of establishing goodwill, but analogized them to capital investments, which were not deductible. Cardozo assumed that the payments to the bankrupt creditors were necessary to establish Welch in his new business, but concluded that they were not ordinary. He admitted that the line between a capital investment and an ordinary business expense was unclear. Quote, here, indeed, as so often in other branches of the law, the decisive distinctions are those of degree and not of kind. One struggles in vain for any verbal formula that will supply a ready touchstone. The standard set up by the statute is not a rule of law. It is rather a way of life. Life in all its fullness must supply the answer to the riddle. My tax professor practically snickered at that one. Cardozo's judicial pronouncements were often obscure in just this way. That is, not arbitrarily, but strategically. He said as much in his 1925 ALI address, quote, "Those of us whose lives have been spent on the bench or at the bar have learned caution and reticence, perhaps even in excess. We know the value of the veiled phrase, the blurred edge, the uncertain line." I examined three well-known examples of his use of metaphor in his opinions, used to obscure the limits of his logic. My claim is that when Cardozo waxes poetic, it is not an accident, but a parapraxis, or commonly known as a Freudian slip, that signals a knowing weakness in the argument. Although it's hard to imagine Cardozo as a poker player, he certainly would have been a bad one. Metaphor is his tell. The paradigmatic example of Cardozo paradigmatic example is Cardozo's much-cited opinion for the court in Gully versus First National Bank, a suit to collect a state tax from a federally chartered bank. The bank removed the case to federal court on the ground that the levy was possible only because of a federal statute waiving what would otherwise have been a constitutional immunity, right? That, of course, goes back to McCullough versus Maryland. Congress waived the immunity from suit. There was thus a necessary federal ingredient in the plaintiff's case, enough to justify arising under jurisdiction under Osborne versus Bank of the United States, another classic Marshall opinion. Cardozo concluded, however, that the federal element was too remote. It's worth quoting his reasoning, and I put reasoning in scare quotes here, it's worth quoting it at length. Quote, "What is needed is something of that common sense accommodation of judgment to kaleidoscopic situations which characterizes the law in its treatment of problems of causation. One could carry the search for causes backwards almost without end. Instead, there has been a selective process which picks the substantial causes out of the web and lays the others aside. As in problems of causation, so here in the search for the underlying law. If we follow the ascent far enough, countless claims of right can be discovered to have their source or their operative limits in the provisions of a federal statute or in the Constitution itself, with its circumambient restrictions upon legislative power. To set the bounds to the pursuit, the courts have formulated the distinction between controversies that are basic and those that are collateral, between disputes that are necessary and those which are merely possible. We shall be lost in a maze if we put that compass by." Exactly what that compass is, we are never told, just as in Welch, we are never provided with a verbal formula or a legal test. The distinction between what is basic and what is collateral is no more helpful than what is direct and indirect in Commerce Clause law. Cardozo offers no compass. Instead, we are meant to get lost in the maze of Cardozo's metaphors and accept his resolution of the question. Indeed, whenever the Supreme Court quotes from this passage in Gully, as Justice Brennan does in Franchise Tax Board, it is a sure bet that it is about to render a judgment, and this is from Brennan's opinion, quote, "for reasons involving perhaps more history than logic." Cardozo turned to metaphors of causation whenever he needed to divert his reader's attention from the absence of an argument or analysis. In concurring in Schechter Poultry, Cardozo, here I'm going to give you another long quote because you can't summarize these, and they speak for themselves. Cardozo invoked the causation metaphor, quote, "There is a view of causation that would obliterate the distinction between what is national and what is local. Motion at the outer rim is communicated perceptibly, though minutely, to recording instruments at the center. A society such as ours is an elastic medium, which transmits all tremors throughout its territory. The only question is of its size." That last sentence is from Learned Hand. "The law is not indifferent to considerations of degree. Activities local in their immediacy do not become interstate and national because of distant repercussions. What is near and what is distant may at times be uncertain. There is no penumbra of uncertainty obscuring judgment here. To find immediacy or directness here is to find it almost everywhere. If centripetal forces are to be isolated to the exclusion of the forces that oppose and counteract them, there will be an end to our federal system." The apocalyptic language, right, at the end, which mirrors the language of the majority in the 1930s Commerce Clause cases, but also what's striking is the sense that he's got the right insight and the wrong conclusion, right? That if the markets are a web, find commerce here, find interstate commerce here is to find interstate commerce everywhere, is precisely what the court in Wickard later says, right? That once you take an economic measure of the Commerce Clause, then the distinctions of direct and indirect and the other mechanical formulas are no longer appropriate. In Carter Cole, where he comes out on the other side, where he's dissenting, and would have held, Schechter Poultry, of course, is the last stop in the chain of commerce. It's the slaughterhouse who then sells to the butchers who then sells to the end users. Cardozo is at the front end of the chain of commerce, right? It's the mining. There he says mining, in that case, is commerce. He cites his Schechter Poultry opinion. Again, the language, I think, speaks for itself. Bear with me, I'm going to give you one last long quote. Sometimes it is said that the relation must be direct to bring that power into play. In many circumstances, such a description will be sufficiently precise to meet the needs of the occasion, but a great principle of constitutional law is not susceptible of comprehensive statement in an adjective. The underlying thought is merely this, that the law is not indifferent to considerations of degree, the quote from Schechter. It cannot be indifferent to them without an expansion of the commerce laws that would absorb or imperil the reserved powers of the states. At time, as in the case cited, the waves of causation will have radiated so far that their undulatory motion, if discernible at all, will be too faint or obscure, too broken by cross currents to be heeded by the law. Always the setting of the facts is to be viewed if one would know the closeness of the tie. Perhaps if one group of adjectives is to be chosen in preference to another, intimate and remote will be found to be good as any. What strikes me about these passages is they say so much and they say nothing. Direct and indirect is not useful, but intimate and remote, there's the ticket, right? That'll help us. And he knows that. But I'm going to make a slightly different point now, and I'm going to transition after this to Paul's graph. Notice three things about the way he uses the metaphor of causation. He shifts them. He goes from a kaleidoscope to a web to a wheel to a series of radiating waves. Second, that these shifts are all imagistically related. They involve a center-periphery or periphery-center kind of notion, although each one is slightly different. And third, that they are different, that each one, although it uses the same general image of the periphery and a center, they have different entailments. In the kaleidoscope, of course, it's the confusion of colors that are revolving, and of course that nicely telegraphs exactly what he's doing in that quote from Gully, right, where he's saying, we don't really have a line for when the federal ingredient is enough of a federal ingredient, and I can't tell you what that might be, but just trust me, we're going to pick it out of the web, right? The web of causation, I think, as I've already indicated, most appropriate in the Commerce Clause, right? Because what is a market if not a web of causation, right? A large polycentric system where when you pull on one strand over here, right, it affects what goes on elsewhere in the market. You, as Lon Fuller said, you raise the price of aluminum and the price of, right, and people are going to start buying plastic to wrap their leftovers instead of aluminum foil, right? So what happens at one end of the web, right, is going to have effects elsewhere. But in Schechter Poultry, where he's going with the majority and saying this is interstate commerce, now he goes for a rigid metaphor. What happens at the rim of the wheel, right, could be picked up by the most sensitive seismic sensors at the hub, but obviously they're not very much related, right? So it's a very sort of strategic use of the metaphors, in some sense admirable and sophisticated, but they do the work of what you ordinarily would have expected to be analysis and argument. And by saying that, I don't mean to make a plea for doctrine, but just rather for some explanation of what he's doing and why. So this brings me to Paul's graph. Paul's graph is not an example of his florid use of metaphors, as these other examples that I've given you. But I think we can see much of the same kind of Freudian slips, these parapraxes, these tells about that Cardozo is up to something. So the first thing I noticed about Cardozo's opinion in Paul's graph is that everyone talks about, right, so he eschews proximate cause. He says it's a question of duty, and the way we teach it, and correctly so, right, duty is determined by foreseeability, but that's a word he never uses. The closest he comes is in the final sentences. He says it was unforeseen. Otherwise, he uses no form of the word foreseeable. He talks about the eye of vigilance. Right? He goes metaphoric on us, right? It's the eye of ordinary vigilance, it's the eye of reasonable vigilance, but it's always the eye of vigilance, right? So like I envision that the Masonic eye that's on the back of the dollar bill, right? The eye of vigilance. So that's the first tell. And this telegraphs, I think, something that's about to happen, and something is about to happen, right? For a judge who's known for his elegance, in Paul's graph, he's surprisingly tongue-tied. Let me read you this sentence. If no hazard was apparent to the eye of ordinary vigilance, an act innocent and harmless, at least to outward seeming, with reference to her, did not take to itself the quality of a tort because it happened to be a wrong, though apparently not one involving the risk of bodily insecurity, with reference to someone else. That doesn't sound like the Cardozo we know, right? But that's taken obviously verbatim from his opinion, right? Why is he suddenly tongue-tied? Well, I think there are three things going on of note here. And that what he's signaling to us, I perhaps deliberately, but I assume subconsciously, is that he's playing a little fast and loose with us, right? The first, which has already been noted, but I want to say a little bit more about it, is his mischaracterization of the facts. As I said over lunch, when Posner and Prosser both agree that Cardozo misstated the facts, it's a fair bet that that's probably true. Apparently, she was only about 10 feet away. He says she's at the far end of the platform. The way he writes the facts, it implies, and I certainly understood it this way as a law student, and understood it this way until I read Judge Newton's book. It implies that it was the reverberations from the explosion that caused the scale to fall, but in fact, the explosion caused a stampede, right? This was essentially the fire in a crowded theater, right? And people got trampled, and Paul's graph and 12 others went to the hospital, right? And it was most likely the stampede on the platform that knocked the scale over, not the explosion. I don't know that that changes the doctrinal analysis of the case. John Goldberg and I talked about this during the break. But the question is, why did he have to change the facts and change the facts so dramatically? As Michael pointed out, right, there was a jury verdict here. So, right, you're going to give an account of the facts. You do the account of the facts that's most consistent with the jury's verdict, because presumably there might have been in the record two different accounts about how far, but presumably the jury decided that in favor of Ms. Paul's graph. Now, Cardozo has told us that he does this kind of thing, right? So in Law and Literature, he said there is an accuracy that defeats itself by the overemphasis of details, the line I quoted earlier. But the line following, I often say that one must permit oneself, and that quite advisedly and deliberately, a certain margin of misstatement. Right? So he's told us that he misstates facts from time to time when it suits his purposes. Secondly, there's a misuse of analogy in Paul's graph, and it's interesting because it's telegraphed with the following line, if I can find the passage, there it is. A different conclusion will involve us, and swiftly too, in a maze of contradictions. Remember about getting lost in the maze if we put the compass by? Well, he wants us to be lost in the maze. That's his goal here. So he gives us the following hypothetical. A guard stumbles over a package which has been left upon a platform. It seems to be a bundle of newspapers. It turns out to be a can of dynamite. To the eye of ordinary vigilance, again, the bundle is abandoned waste, which may be kicked or trod, etc. A passenger far away, right, is a victim of the resulting explosion. Well, it kind of sounds like Paul's graph, but it's not, right? It's the same newspaper bundle. It's a different set of explosives, but it's explosives. The passenger is once again situated much further away than she probably actually was, right? But what's missing is negligence to anybody in this hypothetical, right? In Paul's graph, the conductor is pushing a man onto a moving train, something that they don't do anymore because that's really dangerous, right? And not because of the Paul's graph case, right? In this hypothetical, there's no negligence to anybody, right? It's just piece of newspaper on the floor and you happen to kick it or step on it, right? So it's a complete misanalogy. It works because I guess nobody else has noticed this, but he goes through a series of others, but that's the one I think that stands out. Third, and this will be my last point, and this is a great line, right? You'll recognize it, of course. Risk imports relation. But what does that mean, right? For Cardozo, I think it's relatively clear and clear from the context what he means. He's using import in the older sense, in an archaic, if you look up in the dictionary, you'll say archaic sense, meaning to signify. So risk signifies relation. Reminds us of Jerome Frank's critique of Cardozo's rhetoric. Right? Frank said that it was as if he had a private time machine and went back to the 18th century, right, to learn English. Right? So he's using the imported in its old sense. And if you look at the passage from which it comes, I think it's clear that that is what he means. The risk reasonably to be perceived, defines the duty to be obeyed, and the risk imports relation is risk to another or to others within the range of apprehension. But the phrase risk imports relation strikes me as quite ambiguous and could be understood in a way he did not intend. Right? Risk implies relation. If I make if I'm a manufacturer and I make a plastic bottle and there's a carcinogen in it, right, which causes risks to the significant risk to the end consumers, right? The law is going to imply an obligation there, right? Risk implies relation. I'm going to have owe a duty, right, to the people whom I thereby engendered, right? Because that's not what Cardozo is saying here, right? It's almost the opposite of what he means. There's a third variant, but I'll leave that for the written paper. To conclude, what's interesting, one of the things I find interesting about Cardozo, and in this sense is his greatness as a rhetorician, is that he's a master magician. He's almost like Penn and Gillette. First, he tells you what the trick is going to be, right? And all those quotes, I misstate the facts, right? There's the famous quote from Berkey Railway where he says, metaphors start out by enlightening, but ultimately they mislead reason, right? And then he does just that. He misstates the facts. He uses metaphors to mislead the reader, to mislead reason. But he's a master magician. He tells you what the trick's going to be, then he does the trick, and then you're fooled by the sleight of hand and the audience applauds.
Our final speaker is Robert Pushaw, the James Wilson Endowed Professor at Pepperdine University School of Law. He's going to be speaking on Justice Cardozo on the burgeoning administrative state.
Thank you. Professor Friedman has already touched upon some of my themes. He will be relieved to know that I think he's right. Steve Winter has also beat me to the punch with certain Cardozo quotes, which I think he thinks are sometimes BS. My response is yes, but they're quality BS.
I grant you that.
Distinct from, say, Justice Kennedy's sweet meaning of life stuff. But anyway, so Cardozo's approach to judicial review of New Deal legislation was complex, pragmatic, and balanced. He recognized that courts had to evaluate statutes against the benchmark of a constitution that doesn't contain clear rules that can be mechanically applied to resolve disputes about government powers. In particular, he struggled to reconcile two fundamental constitutional elements. First, the Constitution establishes a democratic system in which legislation is presumptively constitutional. Second, though federalism forecloses interpretations of the federal government's powers that would effectively make it unlimited and destroy state power over local matters. Cardozo reconciled these tensions how? Well, he would defer to the federal government's broad but reasonable exercise of power to address the national economic crisis. But invalidating expedient laws that either gave Congress unrestricted power or the executive branch unbridled discretion. His constitutional approach eschewed any kind of grand theory, especially the notion that the Constitution somehow incorporated laissez-faire economics. Rather, Cardozo carefully interpreted and applied statutory provisions in light of a bunch of things. One would be Congress's overall policy goals. Another were various real-world political, social, and economic circumstances. Another was the particular facts presented. Another was the need for flexibility with this fledgling administrative state that was trying to find its wings.
exercising such delicate judgment on a case-by-case basis really came naturally to Cardozo, who had ascended to the court after earning a reputation as a brilliant state judge who had adapted the common law to meet modern conditions. Although Cardozo lived just long enough to witness the triumph of his deferential approach in 1937 and 1938, his attempt to enforce certain outer limits on federal power proved short-lived. Why? Well, I think Roosevelt appointed nine justices between 1937 and 1943 who were not experienced judges. Rather, they were ardently New Deal politicians or academics. The court swiftly embraced basically absolute federal regulatory power instead of continuing the painstaking process of considering each case individually and developing federalism principles that would restrict Congress in certain instances. I could illustrate those themes by looking at the court's holdings and Justice Cardozo's separate opinions. We'll look at three doctrinal areas. The first is the non-delegation doctrine. Article 1 vests in Congress all legislative powers. Conversely, Article 2 grants the President all executive power to implement those acts of Congress. So the Constitution appears to prohibit on its face Congress from delegating its legislative power to the executive. Nonetheless, during the 1930s, Congress enacted many statutes that announced basic policies in general terms and gave executive agencies broad discretion to promulgate and administer detailed regulations. Constitutional challenges to those delegations succeeded in a pair of 1935 cases, but Cardozo struck a cautionary note. So the first is Panama refining. The court struck down Section 9C of the National Industrial Recovery Act, which authorized the President to prohibit interstate transportation of petroleum that had been produced in excess of state production quotas, so-called hot oil. Chief Justice Hughes held that Congress had violated the Constitution's structure by delegating its legislative power, yet failing to expressly declare its policies and define a standard to guide and limit the President's discretion. In a lone dissent, Justice Cardozo agreed that a valid delegation required a limiting standard, but he inferred one from the statute considered as a whole. Initially, he noted that Section 9C confined the President to a specific act forbidding the interstate shipment of petroleum that exceeded state quotas, rather than allowing him to, and I'm quoting here, to roam at will among all the possible subjects of interstate transportation, end quotes. Moreover, he said that other sections of the statute supplied the limiting standard. The President could ban oil transportation only when he concluded, based on industry conditions, that doing so would effectuate Congress's declared purposes to remove obstacles to commerce, eliminate unfair business practices, promote optimal use of natural resources, stabilize prices, revive industry, etc. But because he was Cardozo, he proclaimed, quotes, "Discretion is not unconfined and vagrant. It is canalized," I didn't even know that was a word, "it is canalized within banks that keep it from overflowing." More generally, he rejected formalism by declaring, quotes, "The separation of powers is not a doctrinaire concept to be made use of with pedantic rigor. There must be elasticity of adjustment in response to the practical necessities of government, which cannot foresee today the developments of tomorrow in their nearly infinite variety," end quotes. And after reviewing many precedents dating back to 1794 that authorized similar delegations, Cardozo concluded, quotes,
There is no fear that the nation will drift from its ancient moorings as the result of the narrow delegation of power permitted by this section, et cetera, et cetera. The second case is Schechter Poultry. It involved a law empowering the president to promulgate codes of fair competition for industry, which he invoked to regulate not merely fair competition, but also matters like wages and hours. Chief Justice Hughes concluded for the court that Congress had illegitimately delegated power by neglecting to set forth any standards concerning such codes, which potentially covered all American industries. Cardozo concurred to explain that unlike the provision in Panama refining, this attempted delegation was not confined to any single act, nor to a class of acts identified or described by reference to a standard. Here is, in effect, a roving commission to inquire into evils and upon discovery correct them, end quotes. He also stressed the breadth of discretion given to the president. Quotes, "This is delegation running riot. No such plenitude of power is susceptible of transfer," end quotes. So the court manifested hostility to Congress's delegation of legislative power. By contrast, Cardozo realized that such delegations were necessary to the functioning of the administrative state, but sought to ensure that Congress enacted laws that dealt with a particular subject by articulating standards that guide the executive branch's conduct within defined limits. Even Cardozo's modest efforts at containing legislative delegations, however, did not last long. True, the court has continued to insist that Congress provide an intelligible standard to guide the executive's discretion, but that verbal formulation is meaningless. As became apparent in 1943, when the FDR court sustained Congress's delegation to the FCC of power to issue licenses, quotes, "in the public interest," end quotes. Indeed, the court never again applied the non-delegation doctrine to invalidate a federal statute. The second area I want to talk about is the Commerce Clause. Before 1937, the court had long held that that clause imposed two requirements. First, Congress could regulate only commerce, defined as trade and commercial transportation, but not productive activities like farming and manufacturing. Second, that commerce had to either cross state lines or it had to have a direct effect on interstate commerce. So applying this precedent, the court struck down New Deal legislation. There are two cases that are especially illuminating. First is, again, Schechter. The court invalidated this National Industrial Recovery Act provision not only because of standardless delegation, but also because it exceeded Congress's power under the Commerce Clause. Schechter focused on the president's enactment of the Poultry Code, which covered not merely unfair trade practices, but many other details. Moreover, the federal government enforced this code even against enterprises whose activities really were confined within a state, including Schechter was a small company that slaughtered and sold chickens entirely within a local area. The court recognized that, one, the statute regulated commerce, right? It's the poultry business. But it held, two, that Congress couldn't reach local intrastate commerce that had at most an indirect effect on interstate trade. In a concurrence, Cardozo emphasized that Congress did have broad power under the Commerce Clause, but he said upholding this particular statute would, quotes, obliterate the distinction between what is national and what is local in the activities of commerce. The second case is Carter Coal, which involved the Coal Conservation Act. That law set prices on coal sales in either interstate commerce or within a state that directly affected interstate commerce, and it also governed labor relations. The court struck down the statute on the grounds that Congress can't regulate productive activities like labor. Why? Because they're not commerce, and they only have an indirect effect on interstate commerce. Cardozo then dissented. He argued that the price-fixing provision was valid because it regulated interstate commerce in coal, a conclusion based on the particular legal provisions as applied to the specific facts, not on labels like direct or indirect. Furthermore, Cardozo pointed out the labor provisions hadn't been applied, so their constitutionality wasn't ripe for review. Cardozo's more generous interpretation of the Commerce Clause gained acceptance the very next year in Jones and Laughlin, which sustained the National Labor Relations Act as applied to a large steel company. Court said, Congress has determined it was necessary and proper to get at even non-commercial local activities like labor relations in order to effectively regulate interstate commerce in steel. And so the court said Congress could reach any commercial activity that exerted a substantial effect on interstate commerce. Cardozo won the war over the scope of the Commerce Clause, but he quickly lost the battle to keep it within any real boundaries by reserving a slice of state power over local commerce. The court immediately extended the Labor Act even to small local manufacturers. 1940, it upheld enforcement of the Fair Labor Standards Act against a little Georgia company. Most importantly, in 1943, the FDR appointees in Wickard v. Filburn ruled that the federal government could apply the Agricultural Adjustment Act to the non-commercial growth of an admittedly trivial amount of wheat by a humble Ohio farmer on the theory that Congress could aggregate the activities of all such farmers to justify the finding of a substantial effect on interstate commerce. That test proved to be meaningless, as virtually every human activity, if you added it up nationwide, would have a substantial effect. Not surprisingly, for nearly 60 years, the court sustained every federal law under the Commerce Clause, even those that govern seemingly local non-commercial activities like crime, race discrimination, etc. The Rehnquist and Roberts courts have carved 3 narrow exceptions to the Commerce Clause. Congress can't ban the possession of a gun near a school, authorize victims of gender-based violence to bring tort suits, and they can't force Americans to purchase health insurance. That's it. Congress can do everything else. Even then, Congress can evade those restrictions. How? By exercising the power to tax and spend for the general welfare, which is nearly absolute. And Cardozo played a transitional role in interpreting that clause. So I want to end with the general welfare clause. The first big case was Butler, which invalidated a tax on processors of agricultural products, the proceeds of which subsidized farmers who reduced their crop acreage. Interestingly, the majority adopted the broad view that Congress could tax and spend to achieve not only the ends listed in Article 1, like regulating interstate commerce, but anything that would promote the general welfare. Nonetheless, the court concluded the 10th Amendment reserved local subjects like farming entirely to the states and prohibited any congressional legislation. Moreover, Congress could not invoke its taxing and spending power either to coerce farmers to participate or to buy the state's compliance. Cardozo dissented. He said Congress's taxing and spending power is plenary, not limited by the 10th Amendment. Congress could address a national economic crisis through non-coercive gifts of money. The dissenters' views quickly prevailed in the next year in Stewart Machine, which concerned a Social Security Act provision that taxed employers but credited most of the taxes paid into a state unemployment fund as long as they satisfied certain criteria, namely that states had to turn over the taxes they collected to the federal treasury. Congress gave money to states to help them administer their funds. Companies said, gee, these provisions violate the 10th Amendment. They invade powers reserved to the states and they coerce us. Cardozo, finally getting a majority opinion, concluded that the act served the general welfare. Why? Because mass unemployment was a national problem. He emphasized that states could freely choose whether or not to obtain this credit. by establishing systems that met federal conditions. So he said Congress had merely induced or persuaded, not coerced, states to establish such unemployment funds. He acknowledged that the line between inducement and coercion might sometimes be difficult to draw, but he left that issue to later development. Once again, Cardozo endorsed generous but not absolute federal power, but alas, his one proposed limit that Congress could induce but not coerce states was toothless. It proved to be impossible, really, to draw that, almost impossible. So for 75 years, the court just rubber-stamped every federal statute under the spending power. But in National Federation of Business, the court unexpectedly struck down as coercive the Affordable Care Act provision requiring states to expand their Medicaid programs or risk losing all of their Medicaid funding. But that case did nothing to affect the countless conditional spending programs that have really badly eroded state autonomy. My time is up, so in conclusion, Cardozo played a pivotal role in persuading the court to retreat from its fierce resistance to New Deal legislation. Shortly after his death, however, the FDR-appointed justices abandoned all restraints on federal power, even the modest and reasonable limits suggested by Justice Cardozo, that trade may have been inevitable, but it has not been costless, as many valuable benefits of federalism have been lost. Thank you.
We have time for a few questions. Yes, sir.
So my question is to Steve. I think, Steve, you probably know that I disagree with you on Paul's graph on many different levels of distinction one, which is that I think something I kind of agree with you with. I don't think the word foreseeability is that important to Cardozo in this case or in the person commentator.
More duty, yeah.
No, duty is important. But
Yeah, besides, it's more duty for him than foreseeability, yeah.
But he actually does use the word prevision, which is virtually synonymous with it, and it does play a role there.
Well, so is the eye of vigilance. My point is not that the concept isn't there, is that he has to fancy it up. My question is, why does he feel the need to?
That's the question I want to go to, and I like your comment, but it's sort of a and but if you look at the Gully case, which I did again, you do, I agree with you that he's sort of spotting a place where if it's reason at all that's operating, it's a kind of reason that he's not particularly good at explaining in a thorough and clear way, and he reaches to language to try to dull the sense of loss there. So I like that observation. But it can be flipped on its head, that observation, which is that he's a man who believes that this is reason, and that everything he's done is articulated reason, and he doesn't feel the same to spell out reasons like this. Not in the one with the fancy words, but in the rest of his opinion, it's not of the same clear sort, but it's reason nonetheless. And that's actually what he says in that paragraph. That is, this doesn't count as reasonable unless you take it in context. And the context is
Yeah, but it's a context that he can't it's a context he can't explain. So I take your point. I actually disagree with it, but that's okay. Right? So I'm not saying what Cardozo claims and has been cited for, that line from Berkey Railway, that if you use a lot of metaphors, that's substituting for reason. Right? I wrote a whole book saying that most of our reasoning is metaphorical. So I'm all for that. I just don't think he's doing that. Right? If he were doing that, if he was expressing his reasons metaphorically, then I would agree with you. I had, it's a formative experience for me, but I spent a great amount of my time at Legal Defense Fund working with Tony Amsterdam on the death penalty cases. And one of the things that struck me about Tony, and Sam knows this story, struck me about Rabbi Soloveitchik, who was my great Talmud teacher when I was in college, was that everything was metaphorical. Now, those are the two most brilliant people I've ever met. I mean, Tony's IQ is probably like, 185, 200, I don't know, something off the charts, and Raleigh Salvegic was extraordinary. So there's metaphorical reason, and most of my work is actually about that. But here, metaphor is being used to obscure reason rather than to explain. It's much more like trust my judgment, checks in the mail, right? It's about the context, and it's very fact specific. And I think if you go back and parse those quotes again, you'll see him saying exactly that. One last thing. I didn't do this in the oral remarks, but it'll be in the written paper. So there's a fundamental underlying problem here that he's grappling with, and it's not a problem unique to Cardozo, and it's the one that came up in both of my co-panelist talks. The line drawing exercise that the law tries to do, right, which in its extreme form is formalism, ultimately doesn't work. The world doesn't fit the neat patterns that we draw up. That doesn't mean we shouldn't have hard and fast rules. Sometimes we should, right? It's just that there are always going to be costs. There are basically three basic strategies you can take to deal with that problem. And there are some variants on the three, but there are basically three. The first is you can face up to it and say, look, I'm going to draw a line. I know the line's not perfect. I'm going to do the best I can. I know that the case on nearest this side is not that distinct from the case nearest this side, but we got to do it. That's what Holmes did. He faced up to it. And I'll put the quote in the file. I didn't have the quote in my talk, but and Cardozo does the opposite. He says, a lot of hand waving. And that's what those quotes say. It's always a question of degree, and then he goes off into some florid rhetorical discussion. The other possibility is to take the all or nothing solution, and I'm doing that as two possibilities, right? So, that's what we did in the Commerce Clause. That's Wickard, right? Wickard says you can't draw a line between direct and indirect. It makes no sense, right? Once you take an economic view of the Commerce Clause, it's all one big market. Everything's connected to everything else. And so my default position is going to be leave it to the Congress, right? Leave it to the democratic process. That's defensible because it's got a justification for its default position. The alternative, which I guess depending on your value commitments is also justifiable, is Justice Scalia does the same thing. Right? There's a fuzzy line here. You can draw a line, but it won't be comprehensible. Therefore, you just shouldn't do it at all, right? I'm thinking in particular of his dissent in Morrison, the special prosecutor case. So I suppose one could have put the best face on it. His default principle is a kind of libertarianism, and that there's an argument to be made for that. But Cardozo's is none of those three. His is to obfuscate, and that I think is not as defensible.
Time for one more question. Yes, sir.
More of the same. Quote, assisting a passenger to board a train, the defendant's servant negligently knocked the package from his arms. It fell between the platform and the cars. Of its contents, the servant knew and could know nothing. A violent explosion followed. The concussion broke some scales, standing a considerable distance away. In falling, they injured the plaintiff, an intending passenger. That's Andrew's dissent.
No, he takes the same facts. No.
So,
Yeah, Marianne Constable's book, when she discusses Paul's craft, points out that Andrew's facts are exactly the same.
So you're making a claim that Cardozo is up to something. So the dissent apparently is up to the same extent.
That may be.
The dissent isn't calling the majority on the thing that he's up to, which makes it implausible. And then the stumbling over the package example, there is negligence. The guard is negligent for stumbling over the package. And so that's careless. Nobody would say, guard, you're responsible if the package then explodes and injures someone standing away. So I just think...
I mean, Cardozo says that it's okay to kick the package.
It seems to me like you're working hard to make this stuff not work. You're working hard to find a way to make Cardozo add up to something. And so now we can use your methodology and ask, what are you up to? What's the tell here?
Fair enough.
What are you trying to accomplish?
Thank you all. Gentlemen.
Actually, Cardozo says a package which may be kicked or trod upon with impunity. So he clearly says no negligence in stepping on the passage. That's his hypothetical. That's a direct quote.
Okay, thank you. And with those closing words, Steve, thank you. And again, thank you all. And it's been wonderful, and I hope to see you next time. Thanks.